May I please, Your Lordship?
Please.
Lordship, there is an issue, Your Lordship, that item number 13 and item number 15 are, the petitioner are same. My lord,
13 and 15.
yes, 13 and 15.
Huh.
My lord, 15, item number 15 is our petition, Your Lordship. We are engaged here.
Huh.
However, my lord, after giving us wakalatnama as well as authority to file this case bail application before this honorable court, Your Lordship, they again entrusted some other advocate, and that is item number 13. My lord, if Your Lordship go through the filing slip or filing number, that our bail petition is we filed the said bail petition earlier. Thereafter, the petitioner again engaged another advocate, Your Lordship. This is a very annoying, Your Lordship, and at least, Your Lordship, the petitioner should, from my side, Your Lordship, that this should be curbed, Your Lordship. After engaging us, thereafter they again engage some other advocate.
That is it.
May I
It
please?
should not be. In fact, while engaging the others, the advocates from your advocate side also,
Yes,
there must be an inquiry. Is there any other? Suppose, I mean, the petitioners are what they want the bail order.
yes.
That much only.
Yes.
So they may be approached by someone's. Maybe there may be many reasons
Yes,
for that. But if for the part of the advocate, at least asking someone that earlier they have engaged any other case, or is there any petition pending?
yes, Lord.
That might be a simple thing. Then the matter would have been, I mean,
Yes.
between there or in knowledge also that one earlier petition is pending, still pending.
Yes, yes, Lordship.
So,
However,
but that is going on. What to say? Sometimes
Yes.
we found that generally we ask that whether you have taken consent of the other side. Then the answer is that yes. But sometimes it happens that the other side counsel come and they say we have not asked actually.
Yes.
The consent was not taken from us, so there may be an interim, there may be any things are there. So
Yes.
that should not be in fact.
However, after filing our bail petition, it was kept on defective, Your Lordship. Thereafter, the said petitioner again engaged some other advocates, and my I think is that may I plead, Your Lordship?
But your one is 988, another one is 985.
Yes.
So you are 985. I mean 13, item number 13.
No, I'm item number 15.
You are for 15.
Yes, Lordship.
Lordship, I am 13, Lordship, item number 13. Lordship, petitioner instructed me to withdraw this petition, Lordship. Item number 13, Lordship.
So now you are going to withdraw this one. Okay, then you will hear your petition on 15 only,
Yes.
if they withdraw. Now he is saying that one petition was pending in spite of that. That is a minimum query. You can
Lordship,
just,
checked it, but
it was defective.
matter was defective, Lordship.
So it should not be a license that he again file another petition thereafter.
No.
Sorry,
He is saying that before filing this, he checked is there any other petition pending, and it was not shown
Not shown, Lordship.
in
Yes.
the I mean system, because your petition was there in the as a defective form was lying before the registry.
Yes.
That may be one withdraw.
Lordship.
Okay, 13 to withdraw for item as per your instructions. What's your good name?
M. Hussain, Lordship.
M. Hussain. Acha, M. Hussain. 3 number number. Okay, it will be disposed of on withdraw. That the same will be higher.
Much of.
Much of it.
My lord,
Yes.
one matter, my lord, where in the against the same FIR, your lordship passed few audits. Now I have filed on bail application against the same FIR. Can it be taken tomorrow?
Bail application.
Bail application.
You're for paying for listing.
Right.
Listing you have to 3 number, no? You have to
It is
approach.
already filed.
No. Court number 3, you can make a mention before court number 3 because he is also dealing with the special bench.
All right.
So it may be listed before me only. And that is not the issue, but make a mention before court
All
number
right.
3.
Published.
I beg to mention item number 8. Does it matter may taken any other day also? As senior is out of station due to Eid.
Now, any other day means it will be after Bihu only. Now, how long your petitioner is behind the bar?
More than 2 years.
Oh, it's a NDPS matter,
No. 302 Lordship.
302. I mean, trial is going on.
10 numbers of witnesses already examined.
already examined.
There are,
But
there are,
obviously it will be
there
after
are
the
17 numbers of witnesses.
17. It will see to it, record, we'll calling for the case record also. Now we can call for the case record. Then it will be a date fixed and record. If record comes, then we can see it.
Lordship.
Okay. Now your name is not reflected here.
Yes, Lordship. My name is there. Lordship. A along.
A Alam. Pardon, Mr. A Alam. Go ahead. Call for the scan copy of the case diary, case record along with the case diary. Let it be listed after we who the 29/4.
Short date. Kamrup
Prior
Metro,
view, we
Lordship.
don't have any dates.
On Kamrup Metro, Lordship.
No, we don't have any dates. Reason is that 25/4 money ka koro paini. 25/4.
DPWS.
May I please, your lordship? My lord, I beg to mention item number 37, my lord. Last occasion case diary was there, my lord, but FSL was not there, my lord. So fix today, my lord, for FSL.
Ah.
I take instruction, my lord. CD has not come, return back possibly, my lord. The gray date, my lord. Item 37. It was commercial quantity, my lord, but recovery is not from him, my lord. On that ground, we have filed this application. my lord. Only co-accused statement, my lord. 23, my lord.
Why FSL is required means it is a charge sheeted one or
No,
not?
no,
a
not
charge?
charge sheeted, my lord. In investigation stage, my lord.
How long he is in custody now?
Near about 3 months, my lord.
3 months.
But recovery is not from him, my lord. Only co-accused statement. 23rd, lord.
23rd.
For FSL, my lord.
FSL both, it will
Ah,
come
yes,
along
yes.
with CD.
CD, my lord.
CD not received, which was earlier returned back. Calling for the LCR, FSL report. Let the matter be accordingly listed on 23rd of
37.
April 2025. Directing the IO to furnish the case diary along with the FSL report. List accordingly. Okay.
Obliged, my lord.
Item number 30.
Item number?
Item number 32, my lord. I filed an additional affidavit on last Friday. I will be allowed to call this record, my lord.
So item number 32.
32.
May I please, your lordship? I recognize item number 46, my lord, from the orders column, my lord.
Hmm.
A report was confirmed that it has not been received, my lord.
42. It was in connection with one of bail application.
Yes. State has filed that.
Watch.
Not available.
Pardon? When? Report not received.
No lordship, on lordship. After vacation. 23rd lordship.
Report.
23,
23rd. Report not received. Issue reminder. Matter be listed 23rd of April.
Obviously.
May it please your lordship. Lordship, I beg to mention item number 35 and 45. Lordship, kindly fix this matter after vacation, lordship. Both the matters.
35
And 45.
45. 35 is BA and 45 is AB.
AB. Lordship, I am appearing on behalf of Mr. S. Munir, but he could not appear today, lordship.
That's Munir.
Yes, sir.
Your good name?
A. Sharma.
Mr. A. Sharma appearing on behalf of Mr. S. Munir. And paid for an adjournment stating that due to personal inconvenience, Mr. Munir is not in a position to appear before the court today. However, it is submitted by Mr. Das, still an additional PP, that scanned copy of the case record has already been received. List accordingly after vacation.
35. In 45 CD is there.
45 CD is there. Oh. 8 to 35 ot rakhibo. Same order lipo 45 ot 45 khali CD received kobo. Instead of scan copy, it is will be CD received. CD, how long it may be, cannot be used. You have to return back, I think. Otherwise, for long, day, CD 45 of Diok CD receipt to CDB return, calling for updated case diary. List accordingly when it can be listed, body matters.
24, Lordship.
24, I don't know, 24, there are matters, many matters.
Then 22nd.
22nd, 23rd, we have fixed lots of matters. 28 for,
28.
28 for, body matters.
License.
Lordship, I'd like to mention for withdrawal of a BA Lordship. Lordship, we fixed for today at 2 o'clock, Lordship.
We have already filed.
Yes, Lordship, pending matter, Lordship.
No, for withdrawal. Why don't you tomorrow?
Lordship,
Okay, then.
okay, thanks.
May it please your lordship. Lordship, I beg to mention item number 36 of the daily list. Lordship, we had filed an additional affidavit. The same may be called for your lordship.
Additional affidavit.
Yes, lordship.
Item 2.
May I please do that?
Yes.
Lordship, petitioner has been behind the bar from 110 days and charge is also framed. So I may be allowed to face the fair trial.
The trial means you are in custody now.
Yeah, in custody. 110 days.
Yes, does. What is
okay,
what is the case about? POCSO. Oh. I'll say POCSO. Then you have to issue notice now.
No.
Issue notice to respond number 2 to Jurisdictional Police Station routed to the office of the registry and the public prosecutor. No formal notice is required to be served on respond number state, respond number 1. However, the so and so on the last occasion, none appeared, in fact. That's why we could not pass any order. So you take steps on the respond number 2 because it's a POCSO one. Within 1 or 2 days, you take steps so that it can come and we can see. So by the way, scan copy be called for. Yes, after Bihu any date.
24.
I don't know, 24 can be 24 when. It will be on 1st of May, yes.
Started May.
First one. First.
I give you.
Item 3.
May it please your Lordship, it's
Yes.
a bail application under 483 BNSS, your Lordship.
Hmm.
The accused person is behind the bar since 11 to 2025, your Lordship. It's an NDPS matter. FIR is in page 2425, your Lordship.
It's an intermediate quantity, I think.
Intermediate quantity, your Lordship.
Since when you are in custody?
11 to 2025, your Lordship. Precisely 52 days almost.
Behind the bar for 52 days.
Did you ever call for me?
8-7?
No.
You're calling for 7.
Yes. Big
7-3. Oh, sorry, 7-4 for 6.
Item 4.
May it please your lordship.
Yes.
Lordship, it charge sheet is lordship. And petitioner has approached this honorable court for the second time. On earlier occasion, while the bail petition was pending before this honorable court, charge sheet was late, lordship. Thereafter, direction was given to the petitioner to approach the court below. Here he has approached lordship and that came to be rejected. Now lordship trial is going on. Section 8 of the POCSO is there, lordship. So scan copy of the record as well as notice to the informant.
How many witnesses are being examined now, till now?
There are 9 witnesses in the cited in the charge sheet and 3 have been examined, including lordship the victim and the
Victim.
informant.
Same order, issue notice, scan copy of the LCA being called for. He is in behind the bar since when?
30 October 2024, 154 days. 2 days.
Yes, when he can be called for.
2nd May.
Taken my lordship after Bihu vacation, already 154 days.
Bihu already 28 for, 28 for.
28. Lordship, could it be
You
to-
take steps for the respond number 2. Respond number 2 can decision of step 2 through judicial police station, same order. Okay,
Obliged.
by listing of 20.
Yeah, please tell us. My lord, in this case, my lord, this, due to the arrest procedure, my lord, Bihans Kumar is not followed, my lord. This is the notice under section 50, sir.
This is the certified copy or what?
Not certified to be collected from the record. So, my lord, I will furnish certified copy on day after tomorrow, my lord. Already I have, but I have not collected yet. But it is fine. That's it.
So case is pending in which court?
This is pending, my lord, before the learned session, just three women.
Yes, does. So he is taking plea of that Bihan, I mean 47 or 50 section.
What is there in legal treatment? If he has provided certificate. Certificate, I will furnish on my day after tomorrow. It is already on where, my lord, but I have not collected, already applied and it is furnished already, but not collected. It is from the record itself. Because case is-
LCR will not receive, by tomorrow it won't reach. If he applies for certified copy, that I don't know, otherwise to, if you insist for record, then it won't reach by day after tomorrow.
I will furnish certificate copy. It will be difficult for us.
Certified copy, if it is, then it may be considered, otherwise too, we don't have anything. Because at the time of filing also, you didn't annex the certified copy. Day after tomorrow is what date? Third. Can it be small matter? Third is. He is taking another plea, in fact. She is saying third is full, I think. Can it be on 7th?
7th, I have some difficulties, my lord.
4, 5. Fourth can be. Fourth. Fourth.
Fourth, my kindly, that may be 8th, my lord. 4th and 7th, I have some difficulties. I have. 4th and
You're
7th,
going somewhere.
8th, my lord.
8. Okay,
Right.
8. Also call for the LCR. We are also calling for the scan copy of it. By the time it may reach also. 8/4. We have called for the scan copy of the LCR and enabling the petitioner side to file their to bring some document on record. List accordingly on 8/4. Okay, realistic.
Item 6.
Yes, Lordship.
Yes.
Lordship, the petitioner, my lord, is behind the bar for 839 days.
Hmm.
My lord, it involves, my lord, commercial quantity of ganja. Lordship, the FIR, my lord, may seen as page 10, my lord. Page 10, my lord. My lord, below portion, my lord. Following which we found contraband articles in possession of 2 persons. My lord, here 2 accused were there. I am Mukesh Kumar. One was Akash Asaria and Mukesh Kumar. Next page, my lord. The below mentioned contraband was seized, my lord. Number 1, it was seized from, my lord, Akash Acharya, and 2 and 3 were from my possession. And if we calculate, my lord, it would be, my lord, 13 kg, 800 grams. 2 bags, my lord, one fast track bag, and another is 424 bag, my lord. 2 bags were seized from the present petitioner. and it would be, my lord, intermediate quantity. However, my lord, charge sheet has been laid under section 20C, and charge was framed on
Altogether, what was the quantity?
altogether, my lord, 21 kg, 800 grams altogether. Now, my lord, 839 days. Now, another co-accused, my lord, Akash Asaria, he was released on bail by this honorable court on 8/11/2023. That is page 107, my lord. It was considered on the ground of length of detention. Now, my lord, he was released, my lord, 510 days back, my lord. And both were arrested on the same day. And in my possession, it was 13 kg, 800 grams. And in his possession, 9 kg, 700 grams, my lord. So, my lord, prolonged detention and on the ground of parity, my lord.
So, like, if you look into that, order date is 8/11/2023. On there are 8 witnesses are there, out of which 2 witnesses are there. Now it may be.
Out of 8, 5
So,
examined. my lord.
Status report is, how much till now, Lordship?
Out of 5, out of 8, 5 examined, my lord. That
Their
is,
Lordship, it is at the fake end, Lordship.
my lord, page 106. Can you see, my lord? It was the last order. Page 106, my lord, middle portion. One PW is present as PW5. He is examined, cross-examined, and after cross discharge. So, my lord, 3 remains now, and the case is fixed on Lordship
One,
7/4 for evidence.
for production, 23, 24/3. For
Yes,
production.
yes, madam. It was for production, and on 24/3, it is fixed on 7/4 for evidence. I have annexed the entire order sheet except the last order, my lord.
Yes, that's it.
LCR may be called for along with the present status.
LCR is necessary, my lord. All orders, my lord, I have annexed.
At the
Only
fake
the-
end of the trial law. So his role has to be there. Look into that. No?
already co-accused, he has been
No,
annexed
soon
on.
after the release of the co-accused, you did not approach.
I have approached, my
But
lord.
now it is at the end of the trial, in fact.
Lordship, that was rejected, my lord. I have approached page 72, my lord. Can you see? After the release of co-accused, my lord, I approached the trial court, and that is the page 72, order dated 11/1/2024, and my lord, 74, the relevant part, my lord. It starts from 73, bottom, my lord. 73 bottom. In view of above, considering above facts and circumstances of the case, and also due to the fact that the accused is a resident of Bihar, and if he is allowed to go on bail, there is every possibility of his absconding. And further, without examining the examination of the informant and other material witnesses, this court is not inclined to grant bail to the accused Mukesh Kumar. Accordingly, bail prayer is rejected. However, my lord, the other accused is also hails from Bihar, my lord. He was granted.
That's what I'm saying. For the grounded petty, if you wanted, then why don't you file an application just before the rejection of that court also you could have come.
Immediately.
So now you waited since 3, 4, 5 months. And now we have come, but the most probably 5, 6 witnesses are already been examined. That is the issue. I don't know what will be the position. So-
For vacation, my lord.
Before vacation to not possible.
Immediately after vacation.
Yes, only 22nd I'm giving you, 22nd.
Obliged.
21st we are opening day, 22nd let it be on 22nd.
Obliged.
And obviously to 800 something days is a very quite reasonable period. He is in custody.
Yes,
We are also on that view. But I don't know what is the stage of the case. If it is already by 7/4, if someone, if 7/4 or today we are, 7/4 is next date, huh? Okay. 22nd of April, call for the scan copy of the case diary scan copy of the case record along with this case diary and the present status of the case. Okay, if we can dispose it.
Obliged.
We'll try to dispose.
Item 7.
Wait, please. It's a charge sheet case, my lord, LCR may be called from.
Is that POCSO or
No, my lord, it's a 302, my lord. 302, my lord. Only, my lord, I'm sorry, my lord. In the cost title, my lord, it's, my lord, the judge's name was not there, my lord. It will be, my lord, sessions case number 109 of 23 from the additional session judge number 2, Kamrup Metro.
So, session case number 103 of 2023.
109.
Oh, sorry, 109 of 2023 pending before
Additional session judge number 2, Kamrup Metro.
additional session just number 2 Kamrup Metro. From that court only, we have to call for the scan copy of the case record along with the present status.
After vacation, any
Obviously
date,
after vacation,
any date, but after vacation. 24/5.
25 by 25 for.
I'm already.
Item 9.
May I present, Lordship? Lordship, today is 27 days, Lordship. Lordship, allegation under section 21B and 29 of NDPS, Lordship.
Today is 22 days.
27 days, Lordship. Lordship, in the meantime,
That's
we call for case diary.
when it can be called. He is in 27 days.
NDPS. After vacation, Lord,
No, obviously after
After
vacation
vacation.
only.
28, 29, Lordship.
29.
29. Call for the case.
Item 10.
Lordship, item 10 is Lordship, it's associated case, Lordship. Today is 656 days, Lordship. Okay, we call for LCR along with case diary, Lordship. Commercial quantity, Lordship.
Call for the LCR along with the case diary and the student status report. List accordingly 28/4 can be 20, 20, 29, same day, 29.
Obliged, Lordship.
11.
In this case also please say Bihan Kumar is not followed in arrest procedure. We'll supply certificate copy on 3rd.
On
3rd of April. Maybe 3rd of April.
no, you are not the available on 4, 5,
So at 8 maybe.
8. Okay.
As a record of that copy of this notice under section 50 or 47 may be called for in the meantime.
It is also it's not charged, is it?
Charge sheet.
Charge sheet.
Charge sheet.
Charge sheet case for call for the scan copy of the LCR along with the case diary, let it be on 8/4. Okay, we have this.
Obliged.
Item 12.
I believe it. Lordship, it is a bail application charge sheet matter, madam. Trial is going on, commercial quantity heroin, madam.
Hmm.
Madam, one
a small defective 15, my lord. This case, cost title, my lord, the case should refer to NDPS case number 15 of 24. It was inadvertently, it was not inserted, my lord. The later annexures will reveal, my lord, case number NDPS 15 of 24. Pending in a special judge Cardian law. Lordship will call for the CD, LCR and the status report, my lord.
No, what is wrong in your?
My lord, that NDPS case number 15 of 24, my lord, it's not reflected in the cause, my lord, cause title, my lord.
Achha, NDPS.
Yes, my lord.
NDPS.
Case number 15 of 24.
It is out of this.
Yes,
section 60.
LIPS sections, number 60 of 23.
So this is pending before which court?
A special judge, Cardian law.
Special Judge Karbi Law.
510 days, my lord, till they get.
Charge sheeted case.
Charge sheet, yes, my lord. Even today it is fixed.
Yes, scan copy of the case report along with the case diary be called for from the space for in connection with NDPS case number 15 of 2024 pending before Special Judge Karbi Law. List accordingly, yes, and can be
Second mail or
1st of May.
24.
24.
Oh, no, yes. 28 or 29.
28.
28 or 9.
29.
29.
Always, my lord.
40.
My lord, the NDPS Act, my lord, the co-accused has been released by the honorable court, my lord, on the ground of not fulfilling the provision, constitutional provision, as well as the statutory provision of law, my lord. I stated in my petition, only, my lord, only see page, my lord, order of the honorable court. The same accused, my lord, accused arrested after 4 months. And with the case, my lord, and no ground has been shown, nothing, my lord, and my lord, I'm sorry to say, my lord, the accused, my lord, recently lost his daughter, my lord, and
No, if you're going to take the plea of Bihan Kumar and all,
yes,
where is the certificate copy of order in this one? We don't have any.
yes, my lord.
Have we annexed?
VN Kumar.
No, we not Bihan Kumar.
Yes, my lord, 77, my lord, can we see?
70,
77 page.
page number 77.
7. Similar case, similar situation, my lord. No recovery has been made from the.
No, we are not on that.
Not, my lord. Yes, only on the provision.
Not on that. I'm saying that the those, I mean the notices under 47 or 50, whatever, they have annexed this one.
Notices has been issued. Only notice to petitioner's mother.
Those notices have you annexed? I'm just asking.
Yes.
Where?
Yes.
Where?
Yes. 64, page 64.
Page 64. So you're saying only 48 was issued, 47 was not issued. Now, how can we know 47 was not issued?
My lord,
This is your submission.
yes, and may my lord stamp copy of the case in the court.
Otherwise, you have taken a good plea. I'm on that, but the question is that you have annexed 148.
Yeah.
But you are saying verbally that 47 was not there. But where from we know that 47 was not there?
See the forwarding report of the accused.
Yes,
Nothing.
in which page?
Yes, my lord, forwarding report, 24.
24.
Type copy is there because my lord, a small letter, original copy, my lord. Kindly see page 25, grounds of arrest. And
In enclosure
in this,
57 is there.
and
That's what I'm
stated
saying.
this.
That's what
Yes.
I'm saying. In the enclosures, there are
57
notice under
BNS
47 and 48 is there.
Yes, yes.
So that's why I'm asking you,
Yes.
from where we will come to conclusion that there was no 47. That's what I'm asking. So if you call for the scan copy, it may reveal that whether the scan 47 was there or not. If 47 was not there at all, then obviously it's a good case of bail. But the question is that where is the order? We don't have anything. So your verbal is saying that
As per my
48.
information, my lord,
Yes.
47 has not been issued, my lord, to the petitioner, my lord.
But now simple verbal permission will not do.
Because co-accused has been released and daughter of the
Now see,
petitioner.
that's what I'm saying. Here, the ground of arrest was there and the accused, it was forwarding report for only for this accused or what?
Only, no, my lord, forwarding only this accused arrested
You
letter.
have
of
not, this is the type copy. You have not annexed and
Yes, my lord.
original one?
26, my lord. Not clearly visible, that's why, my lord.
Acha, anyway, ठीक, okay. So this is the forwarding report for only for this accused.
Yes. Now,
So-
other accused also, my lord, main accused, I annexed
No,
the
no.
forwarding report.
No, it's okay.
Yes.
I'm just saying that this is the forwarding report for your accused.
Yes,
Wherein in the case of enclosure, there are 47 and 48 are enclosure.
my lord.
48 you have annexed
Yes,
with us,
forty-
wherein
Yeah,
the grounds
47,
were not there, but 47 we don't have now.
my lord.
But we are not in a position, Mr. Das also is not in a position when 47.
Yeah, for tomorrow, my lord.
What?
Can-
No, it's not possible.
my lord,
Day after
Yeah.
tomorrow, from where it has to come
that's full, my lord. Only scan copy, my lord.
or whatever.
My lord, he lost his daughter, man. He died on 21/3, my lord.
21-3.
Yes, my lord. My lord.
I don't know. Can it be possible? Say tell us.
Considering the length of here.
Raise the lordship.
Huh?
To raise the lordship.
It will be possible. He is seeking on day after tomorrow. I don't know day after tomorrow. Day after tomorrow is
Day after
third.
tomorrow, my lord.
No, first thing it will reach or not. That's what I'm just
No, scan copy, my.
whatever process will be steps will be taken from the registry when it will reach or not. That is the question. If it did not reach, then again it will be again after Bihu only. That's what I'm saying.
Possible, my lord. After, it's too much, my lord, because he lost his daughter.
I can understand for that reason. Otherwise, we don't have any date. For your reason, just I'm trying.
Yes.
But the third, I don't know. He's saying that maybe at least by 7.
My lord, the Friday, but.
But it will be your at your risk. I'm giving 4. If it doesn't reach, then it will go after Bihu. It will go after Bihu then. Considering your request, I'm fixing it on 4th. But if it doesn't reach, then it will go after vacation. We don't have any alternative. Because unless we peruse, we are not in a position to say anything, whether 47 was issued or not.
Scan
No, as
copy
with
of-
your information, but we don't have anything now here. Okay, we are fixing it on 4th. Let us see. If it reaches by good, if it doesn't, I don't know. Registry will do the needful. Call for the scan copy of DLC along with the case diary. Registry will do the needful in calling this one. Okay, we are fixing it on 4th. We'll try.
Okay.
Ahi person again.
May I please?
Yes.
This is an application under section 483 of BNS. Connected with your lordship, Marisol PS case number 8 of the 2025. Under section 64, clause 3, clause 5 of Bharatiya BNS 2023, read with section 6 of POCSO Act, your lordship. But the accused person was arrested on 24/2/2025. Till date, my lord, he is languishing. He has been languishing in judicial custody for the last 35 days, your lordship. But at this point, your lordship, they call for the CD.
No, not CD. Section 6 is there.
Yes.
You have to issue notice. What
Yes,
did he?
yes, yes.
Issue notice to respond number 2. to jurisdictional police station related to the office of the registry and the public prosecutor, and also call for the case diary. You take steps within 1 or 2 days for the response number 2. When yes,
Yes, Lordship. On 11,
11,
Lordship
no,
on.
we are not fixing 11. I may not be available on.
Okay,
11.
Lordship, after vacation, Lordship.
Obviously after
Okay,
vacation.
Where Lordship 28,
11, we have some problem also. We
Not-
all are going in fact. So
Lordship
we have
29,
20,
9,
29.
Lordship.
29 will do. Okay, 29.
Debrief.
I'm sorry, my lord. My lord, make it 7, my lord. Sometime
7. 14, number 14 to 7 will do.
16.
The application for bail,
Yes.
the case is in this trial stage, my lord. Because the witnesses have already been examined by the prosecution. Otherwise, the informant was a consenting party, except for her age, the POCSO will be there, my lord. Because she stated that her age is 17. Otherwise, they were in relationship for more than a year.
Yes, that is understood. There may be, the relationship may be consensual also. She may be a consenting party also. But now as per this note,
No, she herself says it's consenting party. She
that's
herself
what I'm
says-
saying.
Yes.
She may be a consenting party also. But the question is that cases are registered under 6 of the POCSO.
My lord, that is the topic.
So that is the issue. So
That is
we
the-
have to issue notice. Otherwise, we don't have any alternative. So take steps on response number 2 within 2 or 3 days, so that it can reach
My lord.
by next date. And we are also calling for a cases scan copy of the LCR along with the case diary. And as per your information, how many witnesses are being examined till today?
3 witnesses.
3 witnesses have already been examined. Your petitioner is behind the bar since when?
Since more than 11 months. my lord.
More than 11 months. Okay, then we are fixing it on, but it will be obviously after Bihu only. It will be
Madam.
obviously after
Madam.
Bihu. Scan copy corporate list accordingly. Yes, it is 25.
Madam.
List on 25.
17.
Bail application lordship.
Hmm.
For it to be bail application lordship, offense under section lordship 75 to BNS and related section POCSO lordship, 8 of the POCSO lordship. Today, accused person behind the bar lordship, 19 days lordship. So, lordship.
19.
19, 19.
19.
Yes. Notice may be issued as soon as lordship at sitting may be also. Right?
Notice be issued to respondent number 2 to register through the jurisdictional police station or related to the office of the registry and the public prosecutor.
No.
No formal notice is required to be served on respondent state response number 1. Again, লিখি দিব. Also call for the case diary. Yes,
On 30, Lordship.
30. Now he is behind the bar since when? 19.
19 days lordship, 19 days.
অলপমান আগুৱাই দিয়ক. He is behind the bar.
Then 25th, Lordship.
We are fixing it on 25th.
Let me worship.
Yes.
This is a matter of cyber crime,
Oh,
cyber crime. And in fact, matter what happened, one crypto, my lord. What happened, they purchased the foreign currency. And suppose it become after 15 days, it become costly. Suppose 80 rupees dollars, my lord, for example. I purchased today 80 rupees. After 10 days, after 100, it become 90 rupees. So that, my lord, I have lured the investors to purchase this thing through my app. So this is the investment in my just in order to lure the people, investors, to invest money in that particular app. This is the allegation. But our petition is that matter basically from the FIR, it states that matter one Dubai-based person is involved, another person we are not in that way. We are not involved. Yes, we admitted that, but we do it, my lord. But we are also victim. Because that app, we are also victim, my lord. So this is one part of the FIR, my lord. Second part, my lord, about the notice part, my lord, nothing, your lordship kindly see the notice I have given, my lord. Listen. To of the devotion. Your lordship kindly see. Page 33, your lordship kindly see. Page 33. This is the copies, my lord, you could not annex, my lord, the certificate, copies of the certificate. Page 33. Hmm? 33, 34. Your lordship, got it, my lord. 33, 34, 34. In the quote below also it is mentioned, my lord. Quote below page 35 bottom. Accused person arrested. The accused persons are not involved in cheating any person or involved in the cyber crime. Page 35 I am reading, my lord. Bottom. The IO while arresting the accused persons have not complied with the section 47, 48 of the BNS and thereby violated the constitutional right of the accused person. Accused person jail since so and so and so and so. So this is matter the finding, but no finding or no opinion was given on that particular thing, but simply serious allegation, so bail was rejected. And we have stated in paragraph 6 and 7, your lordship, page 6 and 7, your lordship can be. Paragraph 6 and 7. Your lordship. That the petitioner begs to state that from the order sheet dated 5/3, which just now your lordship, but 5/3/25 and 7/3/25 passed by the learned CDM, where the petitioner has given police remand, it transpired that the learned court below failed to explain whether the notice under section 47, 48 were duly communicated, served with the prescribed procedure of law, because from the arrest memo as well as the notice under section 47, it appears that the investigating officer did not mention about the grounds of arrest, and moreover, notice under section 48 BNS was not served at all, my to any family members, relatives of petitioner as such, quote so and so. Then 7, from the case record, it also transpired that the ground of arrest was not communicated to the family members of the petitioner in proper manner, which is mandatory requirement of Article 22 of the Constitution of India. So now your lordship have seen my that arrest memo I have given. 47 is also there. They have written your lordship have 47 in the bottom top, my lord. So this is my case matter. Nothing, your lordship, not a single ground is given through that game. Our statement
Who is Noor Alam?
Noor Alam is petition number 2. Petition number 2. They are educated unemployed, my lord. Noor Alam, and number 3 is Mahabur Rahman. Nothing is there, man. Just tell it to your lordship, man. Arrested already interrogation, might have been interrogated. Whatever is there, it is everything on the record, my lord. If you have done anything, already they got it, man. Everything there already. Because 20, petition number 1 and 2, arrested, my lord, on 4/3/25. And petition number 3, arrested on 7th. 1 and 2, my lord, today is 28 days. 1 and 2. And 3 is, my lord, 25 days. 1 and 2 arrested on 4/3 and 3 arrested on 7/3. Almost 2 remands already gone, my father is already judicial custody they have sent. So further custody, that is on merit. A second thing, matter because of this completely matter everything null and void, mind.
At the time of arrest, they were on police remand?
At the time of arrest,
No, whether there was any police remand.
yes, it was there. Thereafter, judicial custody. thoroughly interrogated, my lord. Now, because of that's why the Bihan and some Mr. Kumoti, whether I have given your lordship latest order, my lord. Your lordship said other than Jal Khali Hui Jabo, my lord. Your lordship says Jal Khali Hui Jabo, my lord. But law is in my favor, my lord. I think your lordship will consider that, my lord.
Yes, that's.
Yes, Lordship, I have seen only 47 notice of only one person, that is Mohibur Rahman.
He furnished us the certificate copy.
Yes, yes, sorry. Mohibur Rahman, I have next.
One, number one, one is, name of one person is,
Akhirul Zaman. One is Akhirul Zaman, one Nur Alam, one Mahbub. Yeah.
Hafidul Jamal.
Nur Alam.
One is Mahabur, na?
Yes. Mahbub, I have annex also, my lord. But that was not certified, so that's why.
There only, Lordship, I only want to state here that, Lordship, if we look into the FIR 61(2) is there. However, by Lanet Senior also stated that he was doing the business of this, Lordship, Bitcoin. And one of the accused is also in from networking, is also there from Dubai. However, material is there, prima facie, Lordship. But on regard to 47, Lordship, my hands are also bound, Lordship. If it is not there, I cannot state anything on that, Lordship. Otherwise, 61(2) is there, and allegations are also serious economic offense. Organized crime is also there.
Further custody, my lord. Anyway, if you was. Obliged.
No objection may be recorded.
Yes. Set up now. Same.
90.
Your chief, my lord, the petitioner is behind bar for last 34 days, my lord, arrested on 27/2/25. That is a case of elopement actually. Offense is under section 140, subsection 3, my lord. Okay. My lord, this is abducting and wrongfully confining. And punishment is for 7 years. So already 34 days behind bar, my lord. Victim is recovered, my lord.
Have you annexed any statement of the victim here?
No, 164 statement, they don't provide a certificate for the matter. But police, my lord, statement is there, my lord. The background of the case at page 15. During preliminary inquiry to enter,
Page?
Page number 15, my lord. Page number 15, background of the case, second paragraph. During preliminary inquiry, my lord, local inquiry as conducted with the assistant of Branch of Police Station, Ruby Assam, the victim was found with the accused.
Yes, recovery is there. So you are in custody since when?
Well, 27/2/2025. Today it will be 34 days.
Yes, Burma.
So it's from Jalukbari place, madam, we'll fix a salt there to call for a case there.
Whether custodial detention required.
That's it, given fixation. No, those are both fixation. Yes. Tension. Lot of fixed matters we have prior baby who is a very tough position. Because 11, we are not in a position to give any date.
Friday, but otherwise, my lord, whether the materials in the case are there.
Yes, obviously. especially 164 of the victim has to be
But,
there.
that will be okay. And there may be some of adding some more sections also, madam, after recording of 15, 160, 183, madam.
Mhm.
That is why, madam, provision of the case there is necessary.
Obviously, but we have, problem we have with the date. Your petitioner is behind the bar since 35 days,
It will be 34 days.
34 days.
27.
Saturday is my working day, madam, this Saturday. Saturday working day.
Which Saturday?
This Saturday.
We are not fixing this. ক'ত দি থাকিব কাম বেলেগ কাম কৰিব আছে কাম কৰিব নোৱাৰো দুটামান কি হৈছে সিহঁতে ফিক্স ৰাখিব that will be so lots of depending works are there. How can you this not possible? 9, 10 পাৰে যদি চাওক, otherwise 8 পাৰে যদি চাওক. He is behind the bar in fact. 7 কৈছে 7 proceeding.
Item 20, I may be allowed to withdraw.
Want to withdraw this?
Yes,
As per instructions.
as per instruction. Well, actually, I have filed wrong FIR in this case, so I want.
Technical
I
issues.
File afresh.
Heard Mr. K. Thakur is non-counsel for the petition. It is submitted that due to some technical defects, he wants to withdraw the same. It is liberty to file afresh. Liberty is up to you only. Technical issues. They are allowed. Matter is disposed of accordingly on withdrawal. Okay.
Deeply obliged.
21.
Some problem. For the petitioner, list accordingly after 1.
22.
Yeah, please, Your Lordship. My lord, the pre-aris bail application, my lord, notice will go, my lord, section 4 of POCSO is there. madam.
Section. Notice 2 will be. To respond number 2.
My lord, may I pray on,
Registered insurance. Yes.
on 11, my lord?
11 we are not
Lanka,
fixed.
my lord.
Pardon?
Lanka, yes, my lord. Who's I this thing?
No, 11 we are not fixing at all, in fact. Because probability of, I don't know. I am going to Hyderabad, in fact, so. I may be on leave also, that is not sure.
23rd.
Okay, let it be on 11. Let us
Fine.
see if I am not there, then.
Highly obliged. Obliged.
Twenty 23.
Yes.
This is 482 application, Lordship. Here in this case, Lordship, POCSO section is here, Lordship. But the very surprisingly, Lordship, the informant himself is the victim, Lordship, and he disclosed her age, Lordship, suppressing her age, Lordship, and she actually, Lordship, can come to page number 23, Lordship, first, Lordship, before reading the FIR, Lordship, and page number 23, Lordship. And the date of birth, below portion, Lordship, Amina Khatun, date of birth 3/11/2006. But Lordship, kindly come to Lordship, page number 17, Lordship. And the first information report, Lordship. 17. Lordship, there are serial number 6, Lordship. And A, B, C, Lordship. Date of birth 2007, Lordship. And if Lordship, and we have calculated Lordship 2007, then his age is below 18. And her actual here, Lordship, date of birth is not clearly mentioned, only 2007 is mentioned. But apparently, Lordship, and she is a educated girl, Lordship, and she completed the higher secondary second year, Lordship, this year. So, my lord, and only for harassing the petitioner, Lordship, her age is mentioned wrongly, Lordship, mistake, Lordship, falsely, and subsequently this case is registered under section POCSO, Lordship. So, my lord, my submission is that, Lordship, kindly come to now, Lordship, page number 20 is the FIR, Lordship. Very long FIR, Lordship, the original one.
20.
And that is not before the police station, Lordship. It is FIR is lodged before the superintendent of police, Lordship, not before the concerned police station, Lordship. So, my lord, and very big FIR, Lordship, 2 pages, and if you permit, Lordship, I am a big Lordship. If you permit, Lordship, I may be very
No,
long.
now, this can understand, it can be understood, but the question is that you have annexed the Aadhaar card also.
Lordship.
And if you go by the long FIR, that is also creates one kind of suspicion, but as case is already registered under 6 of the POCSO Act. So we are not in a position to say anything, at least we have to issue notice. Otherwise, not in
And
a
Lordship,
position.
Lordship line may be mentioned, and her age proof documents may be submitted before this honorable court, Lordship. That because
If suppose during investigation, if our has collected any such kind of the documents,
Lordship,
say birth certificate or say school certificate, whatever, that may be otherwise what, Mr. Burwa, can it be pass any order?
No, my lord, it will be in the part of the case diary, my lord. Because my lord, when the case will be registered, my lord, I will definitely, my lord, examine her, my lord, age proof, my lord. Question is this.
One line can be added, if any.
Lordship.
Yes, the line can be added. my
Line
lord,
can
and
be
I
added.
do not have any objection.
And Lordship, and another submission, the petitioner number 2 is the father, and he is a higher secondary teacher, father, of the petitioner number 1, Lordship. But my lord, his involvement is nothing, Lordship, but he is, Lordship, a government teacher, higher secondary, Nagabanda Higher Secondary School, Lordship. It's very difficult, Lordship, and otherwise.
Is there any material against him?
Nothing, Lordship, nothing. Only, Lordship, one line is there, as apparently, Lordship, in the FR mentioned. And Mary's proposal was given to the father of the petitioner number 1, but they were not compliant, Lordship, their proposal. That is the allegation. That must, Lordship. And he's a higher secondary subject teacher, Lordship, father. And I have also annexed the, Lordship, identity card page number 24. Senior teacher, Lordship. Otherwise, 376 will come, Lordship. That is not against the present petitioner, and other section is not here, Lordship. Except, Lordship, 506, Lordship. That is available. Have to leave honorable court, Lordship.
Allegation against to, my lord, only this much, my lord. এজাহাৰকাৰী এই ঘটনাৰ বিষয়ে আসামীৰ পিতৃক আজিৰ পৰা 5 মাহ মান আগতে জনাও যদিও আসামীৰ পিতৃয়ে কাকো ক'বলৈ মানা কৰে আৰু গোচৰ কৰিব মানা কৰে। ও 1 নং আসামীৰ সৈতে মোক বিয়া পাতি দিম বুলি কয়।
That much.
গতিকে এলিগেশ্যন POCSO will not come, may not come.
Heard Mr. Airfog, the learned counsel for the petition. And also heard Mr. R.J. Purva, the learned additional PP, a state respondent. This is an application under section so and so in connection with so and so. Issue notice to the respondent number 2 to register date, so to Jurisdictional police station written to the office of the so and so. No formal notice is required to be so and so. Next paragraph. Mr. Hawk further submitted that the accused petitioner number 2 is the father of the accused petitioner number 1, and he is no way connected in the arrest offense. More full stop. More so, there is no material against him to book to attract section 376 or section 376 IPC or section 6 of the POCSO Act. And accordingly, he submitted that he is a senior teacher and senior teacher and will abide by and will appear and cooperate in the investigation of this case if he granted with some interim protection. Next paragraph, Mr. Burwa submitted in this regard that it is admittedly there is no allegation against the present accused petitioner to attract section 376 IPC and section 6 of the POCSO Act. However, he insisted to call for the case diary before passing any order on bail. Interim. Okay, your father, that means the respondent number 2 will be under interim protection.
And Lordship, and I'm sorry, Lordship, page number 21, and her age is mentioned in the FIR, Lordship. Bortoman Ezarkari Bog 18 years, 3 months. So, my
In
Lordship,
FIR also.
FIR, Lordship. And page number
Then why it
21,
is
Lordship,
doing-
in middle portion. And the petitioner number 1 is the pharmacist, Lordship, and I have enclosed page number 25. So, my Lord, why the case is raised under section POCSO, I do not understand, Lordship.
During investigation, I don't know why it is
Lordship.
registered. If she herself stated,
Lordship, page number, Lordship.
but the
21.
more bottom one boy, but when
18
the,
years, 3 months.
when the occurrence took place, when she was when?
There is nothing mentioned, Lordship. It's page
No, no,
number-
when the occurrence took place, when occurrence took place?
No,
That
2 years
was-
ago, man.
There is,
2 years ago. Huh?
2
But
years ago.
obviously, then she was minor.
but there is.
We are concerned with the occurrence,
Lordship,
not the present age.
Lordship.
So obviously, she was a minor at that time.
There is only that is Lordship, the allegation. So,
No, whatever.
Lordship,
But the question is that she was minor.
Lordship,
Or if you consider she is 18 at the time of lodging the FIR.
Lordship,
That's why she lost the FIR also by herself.
Lordship.
Otherwise, my mother, father, whoever it was. Anyway, 1st of May or 2nd of May can be
Lordship, I'm sorry.
7-5.
Lordship, I'm sorry. Can the earlier Lordship,
No.
he's the pharmacist, Lordship.
We cannot give
Immediate-
any earlier date. Sorry.
Immediate after.
No, 7-5. Your petition number 2 is on bail.
Lordship, very long date, others 1 month, more than 1 month. Lordship.
Whatever. Yes. next week.
Published, Lordship, published.
Hey, 21 of Mahoana Silva. Item number 21 of Mahoana Silva. No one appeared at 21. 21. It's 24. None appears on call for the petition. List accordingly after 1 day.
My presence may be required.
Huh?
My presence may be.
Yes, yes.
I am appearing on behalf of CGC Lordship.
CGC, na?
CGC Lordship.
Then appears also, however, Mr. Law, PS Locko, dealer in CGC, appeared for the respond number 2. List accordingly after 1.
May I please? Your
Yes.
Lordship?
My lord, FIR starting from page 99, my lord. Relevant, my involvement, my lord, will find at page 10, my lord. Page 9, 18 years, 9 months is the age of the victim, my lord. I am the father of the accused number 1, my lord. And my involvement, my lord, will find page 10 in paragraph 2 in the second part, my lord. My lord, my respectful prayer will be to read these 4 lines, my lord, even though it's a very big affair, my lord. If I read these 4 lines, my lord, everything will be clear, my lord. The accused has been, however, on information, the incident, second accused, the accused threatened the complainant. Complainant is the mother, my lord, not the victim, my lord, and his family members by pushing them. And from the day after the incident was reported, the second accused has conspired to hide the first accused in an unknown place. Resultantly, it has reduced the dignity, my lord. This is the statement, my lord, as far as this FIR is concerned, my lord. And I am the father, my lord. I am the father,
Whose
my lord.
dignity is reduced?
It is not clear, my lord. Page,
Where is the vernacular one?
vernacular, my lord, will find page 13. If my lord can allow me, I can read this vernacular as well. my lord. আনহাতে উক্ত ঘটনা সংক্ৰান্তত 2 নং আসামী অৱগত কৰাত উক্ত আসামীজনে এজাহাৰকাৰী তথা পৰিবাৰৰ অন্য সকলক অখালিল গালি গালাজেৰে গাড়ী ঠেলা গথা মাৰি বয় বাবুকি দিয়ে আৰু উক্ত ঘটনা জনোৱা 20 দিনা পৰাই 2 নং আসামীজনক চক্ৰান্তমূলকভাৱে অভিসন্ধি কৰি 1 নং আসামীজনক অজ্ঞাত ঠাইত লুকাই ৰাখিছে, যাৰ ফলত মান সম্মান লাঘৱ হৈছে। This is the allegation against accused number 2, my lord. I am not for the accused number 1, my lord. Even though, my lord, the section 61, 140, 64, 131 is there, my lord. I am for the father, my lord. Apparently, on the face of record, my lord, my involvement is, as far as 64 is there, my lord, it's not there, my lord. As far as it is also registered under section 67 IT Act, my lord. But there's allegations all against accused number 1, my lord. Apparently, after 25, I will 25. Abdul. And the age of the victim, my lord, page 9, the first line, my lord, aged about 18 years, 9 months, my lord. And I am not on that, my lord, whether it is a concerning, whether there is a relationship breakout, turn out to be a sore one, thereafter they have lost the FIR, my lord. I am, as far as the involvement of the petitioner number 2, who is, as far as record is concerned, my lord, I am the father. And the allegation against me that I am hiding accused number 1, my lord. So in the face of record, my lord, since there is no involvement, my lord, my respectful prayer will be at this stage, my lord. My lord definitely will peruse the CDs. If anything comes against me, my lord, on the face of it, my involvement is not there, my lord. My respectful prayer will be to consider my interim prayer at this stage, my lord.
Yes, Lord.
And I'm, as far as 67 goes, my lord can come for a second, my lord, page 11, my lord. Page 11. 67, requirement of 67 is also not followed, even though it's not at this stage, my lord. As per the requirement, not below the rank of an inspector, my lord. Here, the line says Sub-Inspector Abhijit Sharma will investigate the case. But as far as this is, will come for the accused number 1, my lord, I am not on merit at this stage, my lord. As far as father is concerned, my lord, my prayer will be. দুটা আব্দুল ভাই একেলগে আছেন, বাপেকৰ নামও আব্দুল ভাই আৰু ছোৱালীটোৰ বাপেকৰ নামও আব্দুল ভাই। আপনারা মিলা নাই কেন? মিলা নাই, মিলা নাই, এটা আপনার আছে নাকি? এটা এখন বার্নাকুলার মোটটা আছে। আপনার মিলে তো এটা সেমি হয়েছে number it is number 15.
Well, this my bail application is not letting, my lord. If Komalpur PS case number 104, my lord, which I am handling, my lord, holding, my lord. And his PS case is different.
Yes, my lord is Moirabadi PS case number 15/25, my lord, under section 61(2)(1).
Copy you are supplied with is Kamal.
The petitioner name is same, my lord, Abdul Hai, my lord. AB number 762. Then the PS case number is Komalpur police station case number.
So we are dealing with Moirabadi.
But it is my petition is not letting, my lord.
Serve a proper copy.
This is to be.
We have to serve a proper copy. My lord is holding Moirabadi, man.
Moirabadi.
I'm also holding the Moirabadi. Probably my friend got a different.
That's what he is saying. His not copy is not there. We are dealing with 762. Your petition is also 762, Borwa.
Yes,
AB 762.
762. My party's name is also same, my Abdul Hai. But PS case is different, my lord.
Yes.
It is a problem, my lord. Anyway, my lord, I am perusing from his application, my lord. Whether the victim recovered or not, my lord. So,
Question of recovery is not
Recovery
there.
is not there, my lord. It's a very fast paragraph says she is there with the mother, my lord. The question of recovery doesn't come. She is 18 years, 9 months and staying with the mother, my lord, as far as first paragraph of the FIR goes, my lord.
But 143 is also there. 140 subsection 3. What your FIR says, you say?
Paragraph number 2, ultimate lines, my lord. 4 lines that I have read in vernacular as well as in English, my lord. And this is also on record, my lord. Mother says, my son happens to be in relationship with her daughter, my lord.
Case diary may be called for, my lord. This is my subject.
মানে আসামি মানে অপহরণ কৰি নি হত্যা কৰিব বুলি ভাবো কেতিয়া there was a threatening part আছে I think.
Threatening part against accused number 1, my lord.
And she
My
was
part-
raped, my lord. Initially, she was raped. Then her my lord picture was taken of my lord.
By my
the
son.
allegations.
All allegation against my son.
Part কৰি দি পেলাই considering the prayer submitted by Mr. Borwa Dibo, he insisted to call for the case diary to know the actual fact of the case. And he is innocent, point to Dibo. Simple Dibo, considering the submission made by so and so. An interim DD. Okay, your petitioner will be under interim.
A.S. Tapada. I'm deeply obliged.
No, Abdul Hai.
For Abdul Hai only.
Oh, acha, your good name. Okay, okay, that will be recorded. So you'll be under interim protection. We
I'm
call
deeply
for the
obliged.
case diary. Yes, Borwa, when it can be.
Interim, my lord, then after vacation.
Any date after
Just
the.
after vacation. May. at the
May,
matter.
my lord.
I'm deeply obliged.
Even 7th of May. There will be some conditions about by all the conditions appear. before you.
Yes, definitely I will comply.
7th of May.
My lord.
26.
Here, my lord, notice will go, my lord, POCSO is there. At this stage only notice, my lord.
Section 6 POCSO. Notice to DD as per number 2. Also call for the case diary. Yes, when it can be listed for
5th or 6th.
5th of May. 5th of May.
I'm deeply obliged, my lord.
27.
Just pass over for timing.
But
Pass over for
time
timing.
being, okay.
What can it be fixed at 2, lord?
No, time being only. Let us see.
28.
May please, Lord. For SCP application, Lord, Lordship will find the offer at page 15, Lord. That is the vernacular one, Lord. Basically, acquisition is under section 14 and 15 of the Game and Betting Act, Lord. Assam Game and Betting Act 1970, Lord. The maximum prescribed punishment is not exceeding 3 years, Lord. And I am not the name accused of the umpire, Lord. But the IO has issued the notice under section 79 of the BNSS, Lord. That is why I am apprehending of arrest, Lord. That's otherwise I am ready to appear before the IO. Cooperate with the investigation, Lord.
Have you annexed the copy of notice here?
Yes, yes, Lord. Lord will find the notice at page 17, Lord. I'm not the name acquisition. Basic acquisition is Lordship under the Assam Game and Betting Act, Lord. 14 and 15. Lordship, at this stage, Lordship, I may be protected. So I am ready to appear before the IO.
Yes, Borwa. Submission.
Alexa 3, my lord, page number 18, my lord. Then
Case
trial
number.
court, page number 18. And trial court, my lord, after perusing of the case, that is rejected, my lord. His bail.
That's it, that is not a short order, Lord. Consider materials available in the case report. I am not at all inclined to extend the privilege of years bail to the accused petitioner. According to the very application of the petitioner read over, we stand rejected, Lord. The arrested petitioner has already been released by the trial court, Lord. The name accused of the umpire.
Case I pray to call for the case there, but he is not named accused, my lord. She has been rejected by the trial court, madam. That is well.
Basic acquisition, Lord, under the Assam Game and Betting Act, Lord. And the maximum punishment is not
Mr.
exceeding.
Gokul?
Lord,
So it was not bailable, Lord.
non-bailable.
Non-bailable.
Lord,
Not bailable, my lord.
Heard Mr. B.K. Gogoi, the learned counsel for the petitioner, and also heard Mr. R.J. Purva, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Gogoi that the accused petitioner is innocent, and his name is also not reflected in the FIR. However, he received a notice under section 179 BNSS to appear before the IO. And hence he is an apprehension of being arrested in connection with this case. Full stop. However, he is ready and willing to cooperate the IO in further investigation of this case, and also ready to appear before the IO, complying the notice issued on him, if some interim protection is provided to the present petition. Next para, Mr. Borva, the learned additional PP submitted in this regard that his earlier bail application by the learned trial court was dismissed, considering the materials available in the case diary, and accordingly he insisted to call for the case diary before passing any order on bail. Okay, you'll be under some interim protection, appear before the IO and cooperate in investigation.
Briefly obliged.
13.5.
5?
13.5.
13.5. 1 3.
Okay.
13. Proceeding. Yes. CDs are available. How many CDs are there?
Six, my lord. Six. And some scan copies are there.
Okay.
May I please? My lord.
Here we have received the case diary.
Yes.
Oh.
Scan
record.
Yes,
Oh.
scan record is there.
Okay.
In this case, my lord, I am seeking bail on 3 grounds. First, my lord, the arrest procedure is not followed as per Reliance. So certified copy is there, my lord. I would like to place this one.
Well, in this case, after the status report was called for.
Is it received, my lord? It is already received. Earlier call for it is received, my lord.
But the scan copy there wasn't.
Obviously, it is there. And second, my lord, prolonged incarceration. It is today is 1 year, 8 months, 29 days, almost 1 year, 9 months. Not having any single witness was examined. 1 year, 9 months about. And third, my lord, section 42, subsection 1 of NDPS Act is not followed, because it is a search procedure done in a godown where the owner of the godown was not named as an accused. At night, my lord, godown was searched and found one Duhul along with me. This is the allegation on it. And nothing recovered from me also. If we go through the thoroughly my lord, FIR and the citizen list. So these are mainly 3 grounds. So I'd like to place, may go to the FIR, my lord. Page 12 is the FIR. Yes. This is to inform you that Honorable SP Karimganj received an information from a reliable source that some drugs peddler assembles at Pakoshangan Bazar for drugs dealing. Accordingly, I was informed by Honorable SP Karimganj at 8:30 PM. Since the area comes under my WB and recorded in wide reference Kirishganj WB GDE number 90 dated 8/7/2023. I then informed OC Karimganj PS about the matter, who assured me to visit at the spot, which is staff as well as to help out at the seizure procedure, and I collected authority letter from the Deputy Superintendent of Police Dr. Karimganj via WhatsApp so and so. Invite reference so and so. Next paragraph. I along with my staff WBC Mir Hussain Ali and
half section armed personnel reached at the spot as shown by source. When we reached at the spot, that is at Bagashagun Bazar, the suspected peddlers were seen inside an open godown of Akabuddin. That Akabuddin was not made an accused. Later identified, and in the hand of Ruhul Ahmed, there were seen a mixed color nylon bazar bag. I am not Ruhul Ahmed, madam. Accompanied by Zabir Hussain. I am Zabir Hussain. Seeing us, they started running away and we could detain two persons, namely Ruhul Ahmed and Zabir Hussain. The suspected drugs were brought by Ruhul Ahmed and Zabir Hussain jointly for peddling. In the meantime, OC Karimganj PS with staff arrived at the spot to supervise the search. Before initiating the search procedure, local and independent witnesses were called upon at the PO, including ward member of that ward. In front of witnesses, one among them, that is Zakir Hussain, so-and-so, a body, and found one wallet and one mobile phone. After that, OC Karimganj briefed the detained persons for their search, and they were served notice under Section 50 NDPS Act in front of the independent witness. Then I started search procedure and seized the following items recovered. Recovery items. Then when the suspected Yaba tablets were weighed by me with the help of digital weighing machines, so-and-so, independent witnesses, so-and-so. It is on 2,108 grams, that is 2.118 grams. The above mentioned recovered items were seized by me as per seizure memo in presence of the above mentioned independent witnesses as per seizure list. So this is the minor exactly case. So BNS says that 50 CRPC not followed, and the prolonged incarceration, not having single witness. I'd like to place on judgment matters. So I have placed, my lord, 4 judgments. One is Bihan Kumar in respect of arrest procedure. Second one, Dhirendra Kumar Chaudhary. His 1 year, 5 months bail was granted. The same aspect, prolonged incarceration, where I was in 1 year, 9 months. Then my lord Shariful Islam 1 year, 6 months. Then Nitish Adhikari 1 year, 7 months. And Sharija Banu, my lord 42-1 is not violated, my lord. 42-1 is violated. These are my lord, this 5 citation in respect of my 3 grounds.
My lord, as per the seizure list, my lord, the contraband, my lord, is a commercial quantity. It was seized, my lord, from the possession of both the accused persons, my lord. Rahul Amin and my lord, this Jasbir Hussain, my lord. Now, my lord, Zabir Hussain. Now, my lord, as 47, my lord, 50 notice, my lord, 50 CRPC notice earlier, my lord. It was, my lord, I have found only, my lord, in case of, my lord, Rahul Amin, my lord. But Zabir Hussain, my lord, that is not available, my lord. So that may be, my lord.
I have supplied certified copy book. Original.
Can do, my lord.
And also it is on record, my lord. Record is there.
And legal.
Your petitioner's name is, no?
Zabir Hussain. And I supplied my certified copy.
I have only found, my lord, the notice of section 50 CRPC in respect of, my lord, Rahul Amin. So to verify, my lord, that may be called for.
Notice of Jabir Ahmed is once inspection memo is there. Most probably arrest memo is also available, but notice is not there. Yeah.
My lord, I have supplied certified copy. I collected yesterday, on Saturday, last Saturday.
Okay.
And arrest memo.
Arrest memo is we have
Notice also I have supplied certified copy.
for Jabir Ahmed.
Jabir Ahmed, I have just supplied madam. Kindly go through that, I have given them. Just 2 lines. Notice is there.
He is supplied with the certified copy.
If it
Section.
is certified copy, then notice may take into note about the serving of section 50 CRPC notice. Because it is not available in the scanned copy of the record.
Duly certified by someone.
And limited also. Otherwise, my lord, after timing of search, my lord, no witnesses examined till date. After
Till
timing of
date.
search, no.
No witness examined.
Search time on 9/4/2024, my lord, almost my lord, 1 year back, my.
1 year 9 months, my lord, I have been in custody.
Okay, I'll pass you.
My lord.
Yes. Two data about one more is there, and this one is also.
These are lots. 483 level different. And next, FRS, I think one was there. FRS is 12 melod.
Yeah.
12 melod, extra one. The original page melod 13. 30 we have received the case diary, my lord, but service report we have not received. Whether this served or not. 56 days even behind the burning. Today is a 56 days, my lord. So another aspect of the matter.
As per office notice also, most probably service is awaited. He is in custody for 50.
56 days.
It's a section 4 POCSO.
No, my lord, not 4.0. It is 14, 15 and 14 to POCSO, my lord. 14, 15. 14 and 15. My lord, there was distributed, my lord, shared some, my lord, photos. New photos, my lord.
14 and 15 POCSO.
POCSO, my lord, the main allegation against my lord, once we, my lord, Bolinson no Gogoi, my lord. He had, my lord, love relationship with victims, my lord. He took the photos, my lord, but other accused person, my lord, these two accused person, they have shared the photos, my lord, which was transferred from his mobile phone, my lord. From the main accused person, my lord. We have only received.
They also shared the photos.
Yes. Otherwise, my lord, considering the length of the situation, I would have not objected, my lord. But only question is that, my lord, whether service is complete or not, my lord. Can it be taken up, my lord, day after tomorrow, my lord? 58 days. We'll try to obtain the service report, my lord.
Fixed the matter on day after tomorrow is 4th, 3. 3rd, I see 3rd so and so. And the learned additional PP, Mr. Bora will make an inquiry regarding the service of notice on the respond number 2. So we are fixing it on 3rd.
31.
That was such a submitted, man.
Well, dear, starts submitted my learned friend is submitting my lord there. But your lordship kindly will look my lord here, my lord there. As per my lord certified copy, my lord. Arrest. Lordship kindly will look this arrest.
No, you just approach. That's what I'm saying.
Yes, ma'am.
Certificate copy you have there may be certificate copy, I don't know, maybe. But on that ground also you approach before the learned trial court below. With an appropriate
This is
application.
my lord regular bail application, my lord.
No, yes, whatever you apply before the regular bail, before the learned trial court below, on the ground which you want to tell me the certificate copy of respondent.
My lord, the scan copy may be called for.
No, we are not going to call. We are going to.
Here, my lord, the NDPS case, my lord. It is my lord, regular bail application, my lord.
The question is that if trial court rejects, my lord, then
No,
it
no,
Then
no,
you
no,
can
but
come.
it is matter of my lord jurisdiction, my lord. I am before this honorable court, my lord, under regular bail application, my lord. Therefore, my lord, it is I may not be, my lord, compelled to
Now
approach.
see, regular bail application, they have charge sheet has already
Maybe,
been
my lord.
submitted, so you have the option to appear before.
I am already before your lordship.
No,
the
you appear before a learned trial court below. That's what I'm saying.
Well, I am, my lord, praying, my lord, LCR, my lord, because my lord is since long back, my lord, is pending, my lord. And this is regular bail application, my lord.
Yes,
Yes, my lord.
you appear before a learned trial court below. I will dispose of the
It
matter.
is matter of, my lord, jurisdiction, my lord. This bail application, my lord, needs to be, my lord, consider on merit, my lord. Because, my lord, this bail regular bail application, my lord. I am praying for, my lord, LCR.
Then
my
okay,
lord.
then there is a very good ground for you for consider your bail
Your
application.
lordship, my
Because case has already been charged sheeted. It's a very good ground for rejection. Otherwise, very good ground.
My lord, I am, my lord, here, my lord,
That very good ground for rejection. Then otherwise, case has already been charged sheeted. Merits are there, materials are there.
my lord, here, my lord, I am relying on the some Supreme Court judgment, my lord. Because this
Whatever
kind of,
we are going to.
my lord, your
fix
lordship
the
also
disposal
passed
of
some judgment, my lord, on this regard, my lord.
What kind of?
My lord, this, my lord, section, my lord, arrest procedure is not followed, my lord. Ground is not mentioned in the, my lord, notice, my lord.
That's what I'm saying. That is a good ground. You can approach before the learned trial court below.
Kindly, my lord, another day, my lord, may come up, my lord.
What another day? Otherwise, you have received anything here?
No, my lord, nothing, my lord.
We have received the, my lord,
Only note.
only the, my lord, note info wherein we have been informed that, my lord, certificate has been submitted, investigation complete. Because CD was case that was called for, my lord.
At that time, itself.
Next week, my lord, any day. Next week may come, my lord.
We don't have any next week. That's what that is the problem. That's what I'm saying. Next week we don't have. Now, most probably, as per my knowledge, the learned trial court below are also dealing with such kind of things. And bail are there, in fact, tomorrow you can file. Instead of waiting for another, say, 15-20 days.
I'm paying time today, my lord. I'm paying time today, my lord. And some
Time? What kind of time?
any other day, my lord.
Adjournment, my lord.
Adjournment.
Yes.
So it will be beyond after BU only
My
that
lord.
that will do. Why?
Because I have some
Once
problem.
charged that we cannot pending it for long, na?
My lord, charge sheet that he is in jail, my lord. Petitioner is jail, my lord.
Yes.
What is in problem, my lord? It will, my lord, consider, my lord, I will place some, my lord, materials before your lordship. And after vacation, my lord, I have no problem, my lord.
No. Why don't you approach before the trial court?
I have problem, my lord. This is my lord. I have taken.
You have some problem.
Yes. my lord.
Personal problem.
No, my lord.
What kind of problem?
Petitioner some problem, my lord.
Petitioners have problem
Yes.
in appearing before the learned trial court below.
Yes.
Why?
My lord, already learned trial court, my lord, rejected, my lord.
That's what I'm saying.
My lord,
Already
my lord,
learned trial
with
court.
all respect, my lord, I am, my lord, on, my lord, law, my lord. I am on jurisdiction, my lord. This court has jurisdiction, my lord. How, my lord, with this petition, my lord, maybe, my lord, compelled to approach before the trial court, my lord. It is a regular bail application. He is pending with lot of expectation before this honorable court, my lord. This case is now charge sheeted, my lord. He is seeking, my lord, to be disposed of the matter on merit, my lord. How petitioner can be, my lord, compelled to approach before the trial court, my lord?
Why are you saying what compelling? We are not compelling anyone.
Therefore, I am praying time, my lord, only. With all respect, I am praying time after vacation, my lord.
Don't say utter word compelling. We are not compelling. We are not the court to
Therefore,
compel someone anywhere.
But from the beginning, I am trying.
What you are not speaking about? What compelling? Why should I compel you?
I am praying time, my lord. Even time is not being granted, my lord. What
Then
I
why
can
are you
say,
saying
my lord?
compelling? Why you are uttering the
I am
word
repeating-
compelling?
I
I
am
am not
repeating-
compelling you.
This court has jurisdiction, my lord, with all respect, my lord, to consider the matter on merit, my lord. Therefore, I am paying time. Even time is not being granted, my lord.
Time will be granted. We are just saying that you are on law points. Some law points are there. I know what your law points you are bringing up here because we don't have anything before us. That's why I'm
Therefore,
saying
after
that if
vacation,
it
even
can be approached before the learned trial court, that matter will be disposed by tomorrow also.
Yes,
That
ma'am.
is the thing.
No,
But
ma'am.
we have to wait for this one because we don't have anything.
Yeah.
That's why, except the report of this, we don't have any.
All
So that doesn't mean that you are compelling. And otherwise also,
Sorry, my
if we
lord.
don't go by the suppose this law provision and all, otherwise also it's a very good case of rejection also because you are after getting the prima facie case only the charge sheet was submitted. That's what we are saying. And definitely what has happened, we do not want to interfere if the charge sheet is there. So it is a very well jurisdiction of the trial court below also to see the matter. That's why we are saying it's not a case of otherwise.
I am sorry, my lord. Matter may come after vacation, my lord.
After vacation, the date 21 do. After view 21, we are fixing it on 21. Oh,
I am sorry, my lord. Dear lordship. Well, someone
21
inform
for
me.
21-5.
Diploma.
21-4, a listing of 21. CD case scan copy of the case record along with the case diary be copied. 32. আগে deal করার কারণে এটা বেশি বাড়াতে
May I please your lordship, my lord?
You have annexed the affidavits?
Yes, my lord, and the affidavit has been annexed, my lord.
Affidavit to ICN.
My lord, in the instant case, my lord, the petitioner was, my lord, detained on 23/6/2023, my lord. He was arrested on 23/6/2023, he was detained, my lord.
23.
Yes, my lord. 20. From my lord, Maligaon railway station, my lord. When he was coming to Kamakya railway station, my lord, no, sorry, Maligaon railway station, my lord, when he was coming from Calcutta, my lord. On 24/6/2023, my lord, he was arrested, my lord. And 25/6/2023, he was, my lord, produced before the learned chief judicial magistrate, Kamrup, my lord, Amin Gao, my lord. Here in the instant case, my lord, nothing has been recovered from the petitioner, my lord. The goods incriminating article was recovered from Madanpur Sheikh Gate from a truck, my lord. And I was arrested from Kamakya railway station, my lord. On the basis of 67 statement, my lord, I was arrested and put behind the bar, my lord. Today, I am behind the bar for 1 year, 9 months, 9 days, my lord. 648 days, my lord. Most important thing is that, my lord, there are Article 22, my lord, two grounds that has been violated. First, Article 22(1), my lord, the, my lord, in the arrest memo, my lord, ground of detention was not mentioned, my lord.
You in the additional affidavit.
The
have you
additional
annexed it?
affidavit I have sent, my lord. I could not annex this document, my lord. This is the document and it is a part of page 72 of the, my lord, LCR, my lord.
72.
72, my lord.
And 72.
And my lord, I saw one by one, or to silent. Focus on the 50.
This is section 50.
In forwarding report, my lord, this is the section 50, nothing has been mentioned, my lord. In forwarding report also, Bidhan Singh said that if you said something forwarding report, that will not come, my lord. Lordship, kindly go to the forwarding report, my lord. It was on page 80, my lord. Annex. No ground of arrest has been mentioned, man.
Eighty of which place?
My lord,
80 from this.
petition, man.
No. Page number 80, you want to show 80?
For my lord, arrest memo is page 70, 72 of the
70.
LCR.
The 72 is a notice. Where is the forwarding?
Forwarding is page 80 of my petition, my lord. Annex 2.
Yes.
Then, my lord, my humble submission before your lordship is that for my lord, to that effect, I file an additional affidavit. I have stated all this time. Before going into that, my lord, I want to show for Article 22, subsection 2, my lord. 22.1, I have shown this document that your lordship will satisfy on this thing, subject to their submission, my lord. Article 22 for 2, my lord, your lordship come to the page 38, my lord, of the complaint petition, their complaint petition. In our, my lord, bail application, page 38. Have you not got it? Page 23, sorry, my lord, para 23. That on 23/6/2022, about 11:40, the same train was reached at Kamakya railway station platform number 2. When Pramod Kumar, myself, my lord, alighted from train, he was identified. NCB to stop him, made preliminary inquiry about him, made seizure of ganja to the NCB. The ganja was seized earlier, my lord, on 22/6/2022 from Madanpur Secret, my lord. Then, my lord, page para 25. The calling Pramod Kumar identified and Kamalakanta Roy Kamakya relation disclosed the Madurai arrested 67C. Notice was issued to Pramod Kumar Kamalakanta Roy to the NCB office and Guwahati, Assam. 23/6. Then Pramod Kumar Kamala requested NCB tracking the NCB. They do not know the address location. In the meantime, Madurai talk Pramod Kumar come to Paschim Baragaon. Thereafter, NCB accompanied Pramod Kamalakanta near Nijon upon calling 15:30 hour 23/6 Madurai reached near Nijon still. That thereafter Pramod Kumar recognized Madurai each other and explained Madurai's role in the case. Next page. Then accordingly 67C and asked them to appear on 23/6 for investigation. Madura requested with them as he do not know location of the Madura brought to the police station. And he was in custody, my lord, on voluntary section 67, the truck driver Anil recorded 23/6/2020 based on confession. He was arrested 24/6/2023. If your lordship go to the my lord 22 subsection 2, my lord, the word has been arrest and detain, my lord. I read that, my lord, constitution, my lord. 22(1), I shall already satisfied. For both 2 points satisfaction, I am arguing on that, my lord. Yes, ma'am. Answer, no? Constitution আছে নেকি?
You can read.
Yes, ma'am. First 22(1),
No, no.
First 22(1), no person who was arrested shall be detained without being informed as soon as be ground such as shall be denied the right to consult with defense, legal practitioner of his choice. Every person who is arrested and detained in custody shall be produced before the nearest within the 24 hours of such arrest, excluding the time for necessary journey. The word has been used from time, place of arrest, court, magistrate, and no such person shall be detained custody beyond the said period without the authority of the magistrate. My humble submission before your lordship is that, my lord, he was arrested in Kamakya railway station, my lord, and he was taken to the, my lord, NCB office, my lord. It is hardly 15-20 kilometers, my lord. So they have to produce this accused person before 24 hours before the magistrate, my lord. That was not done in the instant case. And secondly, notice I have already given, my lord, that was not followed. Anyway, my lord, in merit, my lord, nothing has been recovered from the possession of the petitioner. He was on rail, my lord. On the basis of 67C statement, he was arrested, put him behind the bar. In there, my lord, objection. And the petitioner house has been searched, my lord. I am knowing all this detail, my lord. It will be lengthy argument, my lord. Nothing has been recovered, subject to satisfaction, my lord. My humble submission before your lordship is that I stated, my lord, para 100. Page 100, my lord, of my lord, my lord, additional affidavit.
Regarding lordship, section 50, lordship, we will produce original record, lordship. We will have to obtain instruction from the department, lordship.
My lord, this was submitted before the court, my lord, LCR, and it was produced through LCR. It is not that I have produced, my lord. Through, my lord, from learned trial court, my lord, it was produced. Now, if they want to submit anything, my lord, they have to manufacture these things. That is why I am arguing also 2020 subsection 2 also, my lord. And they did not, also kindly go to the, my lord, page 103. If the charge sheet has been submitted by them, my lord. If there is formal complaint, if they submitted wrong document, my lord, it is their fault, my lord. How can they say at this stage that is wrong document, my lord? My humble submission before your lordship. Para 103, para 4. That the deponent begged to state that when the accuser, namely Pramod Kumar, arrested in connection with this case, NCB official did not follow section 50 of the Code of Criminal Procedure and section 58 Code of Criminal Procedure. The petitioner further states that it is duties of the opposite party NCB that they had not communicated the ground of arrest to the petitioner, which has not done in the instant case. The aforesaid action of the NCB arresting without informing the ground is clear contravention of section 50 of the Code of Criminal Procedure and section 50A of the Code of Criminal Procedures. Then, my lord, I rely on my lord Bidhan Kumar, para 9, my lord, page 106. I have judgment also, my lord. that the petitioner back, para 9, page 106. That the petitioner begged to state that in case of Bihan Kumar versus State of Haryana, another reported 2012, wherein the Honorable Appeals Court has referred 2004 7 SSA 576. In case of Pabir Purkaya, this court as follow. The language is 22.1, Article 22.5 of the Constitution regarding the communication of ground is exactly the identical. Neither the of the Constitution provision inquired that the ground of arrest, detention as per must be communicated in writing. Thus, interpretation of important fact, fundamental right as made by the Constitution bench, while examining scope, Article 22.5 of the Constitution would ipso facto apply to Article 22.1 of the Constitution of India. Hence, we have no hesitation reiterating that the requirement to communicate the ground of arrest, ground of detention, writing a person arrested in connection with an offense, or person placed preventive detention as provided under Section 20, Article 22.1 and 22.5 of the Constitution is sacrosanct, cannot be breached under statute. Non-compliance of this constitutional requirement of statutory mandate would lead to the custody of such detention and being rendered illegal. As the case may be, the deponent begged to state that the aforesaid case also observed that when a magistrate arrested is produced before the line of remand, it is duty of the magistrate to ascertain whether compliance Article 22.1 has been met. The petitioner further states that the reason is due non-compliance of the arrest rendered illegal. Therefore, arrestee cannot be remanded after arrest rendered, and the petitioner further states it is an obligation of the court to uphold the fundamental right of the petitioner. Therefore, it specifically established the statutory restriction do not, para 11, grant bail when violation of Article 21-22 of the Constitution of India. Following this judgment, my lord, our High Court, in NDPS matter, commercial court, 6 months also, bail has been granted, my lord. Yes, I am not reading Bihan Kumar. Your lordship has read Bihan Kumar Mala earlier, because your lordship in judgment has, my lord, discussed Bihan Kumar. Bihan Kumar paragraph I have already submitted, my lord. Next judgment, recently passed by my lord, our High Court, in Joinal Hussain, in NDPS matter, NDPS, no? NDPS matter, my lord. Para 6, 7, 10, 12. Para 6, my lord. Have you also got it? I see never. Joinal Hussain, my lord. Ideal good design. That's after Bihan Kumar.
After Bihan Kumar.
After Bihan Kumar, my lord, this judgment has been annexed. Here in a second. Para 6. Placing reliance on the Honorable Appeals Court in cases Bihan Kumar versus State of Haryana, other decision. Before that, my lord, I have to go to the my lord when he was arrested, my lord. Oh, yes, my lord. Yes, my lord. Para 3. Mr. Das Lanet, Senior Counsel, submitted the petitioner was arrested on 16/9/2024, man. Para 3. Then para 6, man. Placing reliance on the decision on the Honorable Appeals Court in Bihan Kumar versus State of Haryana, 22/5/2000, and the Mr. So-and-so Lanet, Senior Counsel, submitted at the time of arrest of an arrestee, it is bound to comply Section 47-48 of the BNS. By serving and communicating the ground and a right to bail as an obligation person making arrest to inform about the arrest and his relative frame which are mandatory in the nature are in compliance of the provision of Article 21. That second part, my lord, to inform to the my lord near relative, if your lordship go to the Bihan Kumar judgment, third part, Honorable Justice Koteshwar Singh has added this part, my lord, in respect of this part, my lord. By order that the statement 24th statement, the direct inquiry apprised the court provision section 47 was duly complied with the petitioner case and non the affixed today. On instruction, so I am coming para 10. On perusal, it is seen that while arresting the petitioner on 15/9/2024 in the said Bajir Sera PS. So arrest memo were served on the relative of the petitioner, but no such ground. Arrest 47 had been served upon the with a particular offense for which they are arrested with the ground of arrest referring to Bajisera PS case number section 90 2024, section 22C 2529 of NDPS. My humble submission before in this case, my lord, arrest memo was served to the accused person, my lord, and no ground has been mentioned, my lord. One part was not complied with to the near relative, my lord. In case of Bihan Kumar Supra, Honorable Appeals Court held that has been, my lord, I already read, my lord, earlier. In next para 12, in the said case, Bihan Kumar Honorable Appeals Court held that if the mandate of Article 22, here 22, is not followed while arresting a person or arresting, it will violate the fundamental right to liberty granted under Article 21, and arrest will be rendered illegal. On the failure to comply with the requirement of ground of arrest, as soon as the arrest is vitiated once, held to be vitiated when person cannot remain in custody. Accordingly, bail has been granted. Subsequently, your lordship also granted bail, my lord, in one POSCO case, my lord. Next case, Ahmed Ali, my lord. I have annexed, my lord. Same thing has been discussed, my lord.
Okay.
Para 10. Yes, my lord. And the other another judgment, my lord, I have given. Now I am coming, your lordship will come, my lord. One judgment, Soriful Islam, your lordships know very well, my lord. I am behind the bar for 1 year, 9 months, 9 days. Nothing has been recovered from me, my lord.
What is the stage of the case at present?
Out of, my lord, 10 witnesses, my lord, only 4 were examined, not a single evidence stated against me, my lord. And I have gone to the, my lord, witness. All the witnesses are official witness, my lord. They are also not stating anything against me, my lord. And Zakirul Islam, my lord, another judgment, my lord. All are 1.5. I will not read, my lord. Everything judgment is evident. And one thing is that, my lord, expert said there is a sample for below 24 gram, my lord. Expert has categorically stated. There is an opportunity to produce the ganja. They are not produced before the court. We do not know whether they are destroyed or not, anything. They have taken 2 samples, my lord. In Bothilal case, my lord, if there is a uniform, my lord, thing, my lord, suppose that ganja is, my lord, 10 gram, yeah, suppose 1 kg in every packet, then they can do this thing. Also, my lord, I have gone to the judgment one Delhi High Court. If that particularly said when batch number are same, my lord, in the so of syrup, my lord. In ganja, I could not find. But here in the instant care, that is not uniformity in the, my lord, seizing of ganja, my lord. Despite 2 samples were taken, my lord, and that 2 samples is below 24 gram, my lord. That categorically state. Bothilal judgment, my lord, following this judgment, your lordship also passed an order, my lord, judgment. That judgment is also there, my lord. That is my humble 67 sim. Tufan Singh is there, my lord. Mohanlal is there, my lord. Every judgment your lordship knows very well, my lord. And that's the judgment, my lord. And my lord, I have given all the judgment. One thing is important, my lord. Today morning when I read, my lord, that thing, my lord. Why, my lord? What is the Article 22 thing, my lord? That has been discussed, my lord. Para 4 and para 5, my lord. Very interesting paragraph, my lord. I have taken 1 copy. What is, my lord, fundamental right, my lord, and what is legal right? Suppose what happened, my lord, sometimes they may say, although they have not said, I have stated all things, that in pleading you have not said anything, my lord. That you have not said anything, that pleading, so you are not liable to get relief. Para 5 said about the English law and Indian law, my lord. In England, something different, my lord. In India, my lord, each and every stages, my lord, my people, my lord, in layman, my lord, fundamental right has been violated, my lord. So Indian law said, even if there is any, my lord, pleading in the petition, my lord, when the right under Article 21 is violated, my lord, pleading is not necessary. It is their duty to show, my lord, that, sorry, my lord, I should not show the finger, my lord. So their duty to show that my right under Article 21 is not violated. If that is so, I was released on bail. And another judgment I could not take Kamal Dr. my lord. Our High Court take, my lord, release the people for this illegal detention. One person was arrested, put it behind the bar, my lord. And subsequently, when he was released on bail, subsequently another 4 case has been, he was arrested. Subsequent arrest, our High Court said it is because it was illegal because it was produced before, my lord, after 72 hours, my lord. That is why I'm developing this argument, my lord. Article 20, subsection 2, Kamal Doctor. That citation I will give, my lord. I
Yes,
myself
I know.
before
Yes.
because it was the first time before the High Court, my lord. One of the judges, my lord, in the Supreme Court, he called the persons to the High Court, they detain him and release him from the courtroom, my lord. Very in the Kamal Doctor. Recently, my lord, in
Justice Bhuyan.
Justice Bhuya passed this order, my lord, Kamal Doctor. If necessary, I can give the citation, my lord.
I have it.
I agree, my lord.
Yes,
Produce the entire record on.
record is with us.
The original, I will have to.
No,
upload.
sir, now see, question is that we have called for that time only you could have made a prayer for calling for the original one. But prayer was there to call for the scan copy. To scan copy we have received. So scan copies are there which was prepared by the court itself, a court from the court. So we cannot disbelieve the here the others are also facts are also the on facts, other things you can agree. But whatever the on the law point section 50, these are here only. And we have called for the record, this is the certificate, I mean, scan copy. If you cannot disbelieve this one, if it is not available, then it could have another case. Anyway, other sufficient, whatever.
Here, Lordship, final complaint filed on 19/12/20.
19?
19/12/23.
19, 12, 20.
And Lordship, charges frame on 3/4.
Charge is frame now.
424. Till now, Lordship, 4 witnesses have been examined, Lordship. And Lordship, role is there, Lordship. Sufficient materials are there, Lordship. As per the direction of Pramod Kumar, the present petitioner, Aminu Islam bought the consignment from Tripura to Guwahati, Lordship. And Lordship, sufficient materials are there. Train tickets recovered from the possession of the petitioner, Lordship. And call links have been established, Lordship. So, Lordship.
Call details have been also there.
Yeah. Page number 61 is the entire Lordship call details, CDR, Lordship.
61 of this petition or LCR,
Lordship, bail petition,
bail petition, page 60.
Lordship.
Yes.
And number of calls, Lordship, from 19/6/23 to 22/6/23, Lordship, from with Amirul Islam, Lordship. Page number 75.
These are the, you mark the role played by. Is
I will
present,
read-
name of the present petitioner is Pramod Kumar.
Pramod. 4 pairs, Lordship. Page number 75.
Yes.
Para 117.
Hmm.
That as per the statement of arrested accused Amirul Khan, Anul Khan, he stated that Pramod Kumar directed him to go to Tripura to bring the ganja laden trucks from Tripura to Guwahati, Madurai. He also stated that the mobile number of Pramod Kumar, so and so, so and so. That as per the statement of arrested accused Pramod Kumar, he stated his mobile number so and so, and he also stated that 2 SIMs were given by Sujit Da of Tripura for purpose of smuggling of ganja. That as per the statement of arrested accused Pramod Kumar, he stated that he sent Amirul Khan, driver, to Sujit Da to Tripura to bring the ganja. Lordship, kindly come to the page number 76. G, Lordship. That during the investigation, a railway ticket known so and so was recovered from the arrested accused Pramod Kumar. On verification from Deputy Chief Commercial Manager, it is found that source Howrah and the destination was Guwahati. Time, Lordship. Lordship, this is the sufficient and call links have been established. Train tickets were recovered from June. This is the sufficient material.
Okay.
Lordship, regarding Lordship judgment, Lordship, I will submit some judgment, Lordship may consider. And we have filed our objection also, Lordship. Consider these two judgments. So Lordship, this is my humble submission. And Lordship charges frame on 3424.
Yes, I have.
Yes, sir. Why?
Represent Lordship. One more submission regarding Sariful Islam. The bail was granted on the facts and circumstances of the case, that 1 year, 7 months. So there was no law or a precedent laid down by the Supreme Court that 1 year, 7 months bail should be granted in NDPS. So no law has been laid down. So it was granted on the facts and circumstances of the. And regarding this case, the facts and circumstances are different, and 4 witnesses have been examined. So Lord can concede.
Sure.
Information. My lord, she said that train ticket was my lord recovered. Obviously, my lord, I am coming from Howrah to Guwahati to my sister house. So train ticket, obviously, regarding this, my lord, call record, my lord, they have to theologically go to the phone was in the name of Nomita Das and Ujjwala. My lord, they are in objection, they have filed, para 104. Page 104. And because not in the name of Pramod Kumar, they have not produced any document to show this phone number is Pramod Kumar. And most important, 65B certificate is not available in the instant case. Nothing. And Nomita Das and somewhere. So Ujjwala was also not witness. That is my
So these are called delays from one Nomita.
Nomita Das and Ujjwala. In their report, in their page, I shall mention, madam. Page 104, madam. Of their objection, madam. Para 21, madam. Nomita and Ujjwala, Pramod Kumar phone. And other are 67 statement, madam. And I am coming to Guwahati, and the truck were going from Guwahati to towards Rungia, madam. Ini angman kota ulang. Nggak soplas.
Yes. So kiman listing mo basta so please answer wo you ek baje no mera yes.
May I please, Your Lordship? The 482 application, Lordship. Lordship will come to the FIR, Lordship. The FIR at page 16, Lordship, Annexure 4. I'm reading, Lordship. Respectful submission is that I, Jainur Ali, son of Surhab Ali, resident of Hatigaon, Vishnujyoti Pot, house number so-and-so, PS so-and-so, would like to inform you that today, that is on 16/3/25 at around 9 p.m., while my friend Baharul Islam Swift Desire, bearing registration numbers AS01ET6725 was proceeding towards Ganeshguri, then one black color Scorpio bearing registration number AS01FS66687 collided with my friend's vehicle at a very high speed and damaged the backside of the vehicle. And in the name of compensation and for mutual understanding, the two unknown boys seated in the Scorpio vehicle took my friend to Rukminigao, and at that time, I, along with my girlfriend, arrived at Rukminigao near Novotel, and at that time, the two unknown boys who were sitting in the black color Scorpio came out from the vehicle with sharp and touched on the chest of my girlfriend, and by snatching gold chain from my neck, fled away by the vehicle. This is the FIR, Lordship. Actually, what happened, Lordship? This Scorpio, Lordship, is the petitioner's Scorpio. They were coming, Lordship. There was an accident, Lordship. When they applied brake, Lordship, suddenly they damaged the brake of the Swift Desire backside. And suddenly he called this informant and that girl, and they came and they started fighting, Lordship. Then thereafter I left, Lordship. They were demanding money, Lordship. So when I refused to pay, I said that I will repair the whatever is that damage I will pay. But they were demanding in excessive, Lordship. And by exaggerating that fact, Lordship, they have filed this FIR, Lordship. So I am not a chain snatcher, Lordship. I have annexed some documents, Lordship. I am a businessman, Lordship. I have like a CSP, Lordship. I used to do registration works, Lordship. These are some of the certificates which I have annexed from Annexure 1 to Annexure 3, Lordship. So my humble submission is that, Lordship, the police visited my residence on 27/3, Lordship, and asking me to appear. So I want to appear, but Lordship, since there are two non-bailable sections, Lordship, I may be detained, Lordship. This fact that accident part is correct, Lordship, that those are bailable sections, Lordship. The other thing, Lordship, that chain snatching and all, they just make the offense grave, Lordship. They have added that part, Lordship. This is my humble submission, Lordship. I will appear, Lordship, and cooperate with the investigation.
Your vehicle was collided with this one, other vehicle.
Yes, Lordship. And he has not lodged the FIR, Lordship. That person has not lodged the FIR, whose vehicle was damaged. That is Baharul Islam. They said only his friend Baharul Islam's vehicle. And we are ready also. We want to make good and we want to pay for that also. But they were demanding more, Lordship. And this boy came with the guard. They were demanding more at the night time, Lordship. And then we left, Lordship. And after that, they lost the FIR, Lordship. Alleging that they snatched the chain and from the boy, Lordship.
Yes.
This for police station.
I will be protected, Lordship, at this stage, Lordship. I will appear and I will cooperate with the investigation, Lordship. And my father is also a contractor, Lordship. I have made a statement, Lordship, because
By Mr. M. Ahmed, the direct counsel for the petition. And also had Mr. R.J. Purva, the land of the PP, appearing on behalf of state respondent. This is an application in section so-and-so in connection with so-and-so. It is submitted by Mr. Ahmed that the present accused petitioner is innocent and he has not committed any such offense as alleged in the FIR. It is a fact that he is the owner of the black Scorpio vehicle, which made an accident with another vehicle. And there was an altercation, and the present petitioner was also ready to pay compensation for the damage of the vehicle. But when they started demanding more, he refused to pay the demanded money. When the informant and her, when the informant arrived at the place and they started quarreling with the present accused petitioner. And that apart, thereafter he left the place of incident. He received a notice from the police and he is ready to cooperate the IO in further investigation of this case. But as there is some non-believable sections, he is under the apprehension that he may be arrested in connection with this case. Accordingly, he submitted that some interim protection may be provided till the next date of till receipt of the case diary. Mr. Borba, the learned additional PP submitted in this regard that CD may be called for at this stage to know the actual fact of the case. Fact of the case. Sorry for considering the submission for reply detail. Okay, you will be under interim protection. Appear before the IO, cooperate in the investigation. Happen 7 days.
7/5.
7/5.
7/5.
7/5. We will investigate on 7/5 for CD.
I am obliged with.
Oh, why again this one again?
My lord, that was placed before the registry. I have made an application before the registry. But that was, the registry heard me and placed before the registry and pursuant to the notification that was placed before your lordship. This is office note reveal that, man. Kindly see the office note.
The court is not available, I think, that coordinate bench.
Now it is available probably.
No, not available, man.
Not available.
Not available. So my lord, it is placed because as per notification that may be taken by your lordship.
Because subsequent notification is there where from if the person, the court is not available, the coordinate bench is not available, then bench by the others. Anyway, otherwise, what is the case about?
I'm seeking bail on my lord 4 grounds. Number 1, my lord, in respect of arrest procedure, Bihan Kumar is not followed. Only, and that is in the part of the record, my lord. And second, my lord,
Have you annexed the notice and all?
not annexed, but it is on the part of the record. It is on the record.
My lord, if he is my lord paying bail on 4 grounds, my lord, then I have to go to the case, my lord, scan book of the record. Now, since there is an order, my lord, I thought that my lord, the matter will be not taken up by this honorable court, my lord. That is why I am not going to the scan copy, my lord. So let it come some other time, my lord. I'll go
Taken
to
up
the
at 3, my lord. It's nothing. It is, my lord, kindly have a look for a moment, my lord. For 5 minutes, I may be allowed to submit. There is nothing more in
can
this
submit,
case.
my lord, that I do not have an option, but
I
my
may
lord,
be-
for me, my lord, I have to go to the scan copy, my lord.
I may be allowed to submit. my lord.
Tomorrow, okay. Let it be on
They are
tomorrow
for
then.
tomorrow.
Okay. Otherwise, you have you annexed the copy of the notice and all these are?
His notice is not annexed, but it is on the part of the record.
Record.
I have seen that, my lord.
Okay, we'll see. Okay, tomorrow we'll listigate.
Obliged.
List tomorrow. You can go through the record by.
Yes, my lord.
Second.
34.
May it please your lordship. Here in this case, lordship may kindly take up
Yeah,
the.
which one matter? Last matter was HRS Chaudhary's. No, HRS Chaudhary's matter was?
Yes.
Huh? It was 32. Last one. And what about 32?
Last.
It was heard, no, for order, no? Oh, okay. 33 is then tomorrow. That is on 2nd. Yes, Ahmed.
Lordship may kindly take up the additional affidavit, lordship, that page 51.
Additional affidavit. This is the very from the all upon form of party against it. This is your additional affidavit.
This is the additional affidavit. This is the document which was lordship, the certified copy and original certified copy I have handed over to your lordship. This is the Xerox copy. That certified part is not there, therefore I have given the certified copy also. No grounds are mentioned here. And page 52, your lordship will find that was the information given to the accused person. No grounds are mentioned there. So this case clearly falls under that category, which is the Bihan Kumar's case, where it is said that grounds of arrest is required to be informed to the arrested person, lordship. And with this regard, I'm not relying on the entire those cases. Just instead of I'm placing one order passed by your lordship. That if initial arrest is illegal, then subsequent remands also goes, lordship.
Yes, Borbai, basically his submission is on 47. As well as in arrest memo also there are grounds of arrest are not available.
Not there. And even to the family members which were furnished to them, that is in that are also not. No,
Family members you have annexed here?
yes, page 51, lordship will find. Page 51 is the documents given to the family members, and page 52 is the notice given to the accused person.
Yes. Otherwise, what is the case about?
Case is lordship about it was recovered from the two FIR name accused person, and they reveal my name. Subsequently, after 7 days, I was arrested in the present case.
You are Zakir Hussain.
Nothing was recovered from his possession. Merely the co-accused statement. And what basis there I was arrested, that was not informed.
So you are arrested only 67 or?
On the basis of section 67. And although charge sheet is submitted, but that will not validate the illegal arrest. That is my submission.
Otherwise, case is already charged.
Already charged.
Charge also framed, my lord. 18/3/2025 charge.
That part is already clarified in Bihan Kumar's case.
Charges frame on 15?
18/3, my lord.
18.
18/3/2025.
23, 25. Oh, very recently. Okay, that's what we'll do.
No, regarding my lord, the 47 notice, my lord, what my understanding, my lord, annex, my lord, and about the additional affidavit, my lord. This shows, my lord, this is the same procedure followed, my lord. Now, of course, my lord, they are, my lord, rectifying. Not
Actually, there are
rectifying, my
two
lord.
defects.
They are like-
One, the investigating agencies were not aware of about the provision or what is the constitutional right. Second thing is that the form itself is there is no scope to incorporate this right. So now there most probably 1-2 matters I have already seen.
Right.
Now they may do this.
Now even in
They
fact,
start taking-
yes, in fact, Supreme Court recently, just few days back, passed another judgment where it is says ground of arrest and arrest memo are two different things. Mentioning the grounds in the arrest memo will not suffice. They have to
Yes, yes.
provide a separate grounds of arrest.
In
That is-
fact, in the notice itself, there
Yes.
should be a ground.
Yes.
Otherwise, that is a 47 or
47.
48. There are. Otherwise, what they have done that at the time of forwarding, obviously there are grounds of arrest.
Yeah, sure.
That is there.
So, my
And
lord,
in fact-
in discount only, my lord, because otherwise, my lord, cases of 2024, my lord.
Very
And
simple.
charges have already framed, my lord.
Yes.
So, my lord, that part may not be tasked, my lord, because only on 47 notice and my submission may be recorded, my lord.
Obviously. Obviously. One judgment most probably in Purkasta itself. It is also observed that the grounds of arrest and the reasons of arrest are also different.
And that is clarified in another judgment, the recent
Yeah,
judgment.
recently.
Because in that case, it was mentioned that co-accused has implicated you. Just I am placing that judgment before you. In this case, it was mentioned that co-accused has implicated you. So the Honorable Apex Court said there is no specific grounds that who implicated, who are implicated, those things are not there.
Okay.
So that is also there. That is in second paragraph, second page, your lordship will find. we are inclined to consider only the last issue. Middle portion, issue raised by the appellant with respect to the non-furnishing of the grounds of arrest. On perusing the annexure 3, we can see that what has been provided to the appellant is only an arrest memo in the prescribed format, which is meant to be given to the appellant by way of an intimation. It has been filled up with the name of the appellant along with the place of arrest. Additionally, it has been written that he has been arrested based upon the statement of co-accused. We are in agreement with the submission made by the learned senior counsel appearing for the appellant that the said arrest memo cannot be construed as grounds of arrest, as no other worthwhile particulars have been furnished to him. So it is going further.
Okay, then we'll pass.
All right.
Okay. 36. Oh, 36. Affidavit আছে না এটা?
My lord, may I kindly take up this small. This is my case. This is, I'm sorry, there is little overwriting, my lord, my junior while calculating the days. And my lord, to be
What is your in addition?
my additional affidavit, page number 22, my lord, may see. And since morning your lordship is hearing arguments on ground of arrest, so I need not bother your lordship with any more submissions on that, my lord. Only this.
This is of arrest memo.
Arrest memo. There is nothing.
And one notice is also there.
My lord.
You have not annexed the notice?
Well, my lord, because that copy I have seen even in the LCR also I have marked, my lord, it is the arrest memo. There is no specific ground of arrest. Ground of arrest been intimated or communicated to the petitioner.
No, apart from arrest memo, do you have annexed the notice also? No.
No notice I have not annexed, my lord. I have put not even subject. And these are the, my lord, only these three judgments I am relying, two on prolonged incarceration and one on this ground of arrest. And these three judgments contains all other judgments. And therefore, I am not placing those judgments on record. Even the para numbers also, my lord, I have specifically given, my lord. I have made a small, I put a small flag mark for convenience of the court in those cases. Because the arrest memo, I don't find, my lord, any ground of arrest being communicated. And in the LCR, my lord, there is no ground of arrest separately communicated, my lord, to whatever. These are the judgments, if your lordship kindly.
Just have you gone through the this scan copy? Whether there is the apart from arrest memo, the notices are also available or not?
Go through, my lord.
Flag mark for this.
Because morning hours, my lord, I have been told that this matter has been adjourned, my lord.
Adjourned?
No.
No.
That is why, my lord, I could not. That is why I did not go to the.
Oh, no, it was a prayer that one additional affidavit is going to be filed.
What are bonus? Notice to arrest. There is nothing. That notice is there. There is nothing.
Notice is also there.
Notice is there. There is nothing. No ground of arrest. I have flag marked both from the NCR.
Now, how many witnesses have already been examined?
4.
Out of
8. 2 years, 4 months, 3 days. Even on prolonged incarceration, also this is a case for bail.
Hello, the only question is that, my lord, they are not belongs to Assam, my lord. So there may be some strict condition, my lord. Strict condition. I'm deeply obliged.
What I used to do, one format is with me, with the party. So these are things that successful already. So it is preliminary looking as a kind of submission, other set of submission that I used to give him. If we get already in a nutshell, yes. So he can type already. So it can be give a course or due to the party. Yes. That is it, right? And the state or one of the objections I have already noted. So if anything is there, I'm not come to advise. There are lots of things. That is 2 matters are already there. And this you can directly quote him. Other one I'll give to the petition. Okay, we'll pass it.
My lord, I'm told by my friend, my lord, because in that written note, it is 857. Actually, he correctly it was typed as 854 days. The days is written 857. It is 854 only. The type 1 is correct. 3 days, yes.
Okay.
May I please your lordship. 483 application lordship. Lordship will file the FIR at page 13.
13.
482. 482 application.
13 is the FIR.
The allegation in the FIR is that, my lord, 2 youths were missing from their locality, my lord, and thereafter the family members doubted that they have joined in the Alpha organization. That is the main allegation against me, my lord, in the FIR.
So you are an Alpha cadre?
No. I am a businessman, my lord. And even against me, my lord, no any allegation in the FIR as well as in the forwarding report. Why I have been forwarded? That is also not mentioned in the forwarding report, my lord. Below the contents of the forwarding, only my name is there, nothing else.
Where is the forwarding report?
Forwarding report, my lord. Page 15. Page 14, my lord. Sorry, my lord. Page 14. Against me, specific allegation is not there, my lord. I am a reputed businessman, my lord. I have been arrested on 6/2/2025. Four days, my lord, without any allegation, my lord.
Your petitioner is?
Petitioner is
Janta
Gharkulia, my lord. Already all the accused person had already granted bail, my lord.
My lord, may kindly come to page number 14, my lord. Page number 14, my lord, first, second, third paragraph, my lord. 3 lines from the, my lord, down, my lord. Third paragraph, 3 lines from the down. It come to light during the investigation that the following arrested accused person has engaged himself in the recruitment of the youth for the Alpha I for the last few years in the entire Dibrugarh district and area of Upper Assam. Accordingly, the following persons is arrested under the following grounds of arrest. And my lord, case there also, my lord, says, my lord, there are sufficient materials collected, my lord. He is the person, my lord, he is a businessman, my lord, that is true, my lord, but my learned friend has submitted. But he has got direct link with the Alpha, my lord, and he, my lord, through him, my lord, the cadres are recruiting, my lord, press cadres are recruiting in Alpha, my lord. He arranged, my lord, all the press cadres. So this is a very serious allegation, my lord. Let the investigation be complete, my lord.
My
Today
lord,
is only 55 days, my lord.
my lord, page number 17, my lord, annexure 3, my lord. What the learned prosecution of the district court had said,
Page number?
page number 17. Reject order, my lord. Page number 17, para 5, my lord. Had the learned counsel for the accused person, the learned public prosecutor, and peruse the case diary. The learned additional public prosecutor stated that the IO has not prayed for extension of the period of investigation, but she objected to the bail petition, stating that the allegations are grave and serious. There is no any objection from the prosecution side, my lord. Only now it is 54 days behind the bar, my lord.
Was it the time for extension prayer?
Yes,
Can
1013
No, that is in respect of other accused person, my lord. Because as far as this accused person is concerned, my lord, he has only completed 55 days, my lord. Now, after completion of 90 days, my lord, if, my lord, the public prosecutor found, my lord, that further investigation is required and for that further time is required, my lord, extension of time is required, then public prosecutor will file an application, my lord, in consultation with the IO, my lord. That, my lord, further time is required. Now, this what he has submitted, my lord, that is in respect of other accused person, not in, because this accused person, he has only completed 55 days, my lord. So, question of extension of his time, my lord, that does not arise, my lord, at this stage.
My lord, that order dated 3/3/2025, the bail petition is filed by me, my lord. For only the accused persons is joined the Gorkulia, my lord. There are no any other accused persons. Page 16, my lord, annexure 3, my lord. Para 2. For me, the submission was there, my lord, by the learned prosecution, my lord.
That question does not arise, my lord, because today is 55 days, my lord. And when this bail application was
Reputed, my lord, businessman, my lord, no allegation, specific allegation is there, my lord. No any specific allegation is there in the FIR also. Only the mere suspicion, my lord, he was arrested in connection with this case, my lord. 54 days, my lord. And otherwise, my lord, he is a chronic liver patient, my lord, liver cirrhosis patient, my lord. Document is medical document 19/32, my lord. Chronic liver patient, my lord. Sufficient treatment was not going on in the judicial custody, my lord.
So this is it.
and my lord, as per the execution order, my lord, there are also 164 statement, my lord, implicating the person, my lord. This present petitioner, my lord. So allegations are very serious, my lord, and I'm not saying, my lord, there are only allegations, my lord. There are sufficient materials, my lord, in the case diary, my lord. That he is the person, my lord, through whose, my lord, the new cadres are recruiting in Alpha, my lord. So, my lord, this is very, my lord, threat to the nation, my lord. And my lord, youth, my lord, young youth, my lord, their life is in jeopardy, my lord. So at this stage, my lord, I oppose this bail application, my lord, that the investigation be continued, my lord. At this stage, my lord, I am opposing.
My lord, investigation has might have already completed because the submission of the IO, my lord. What is submission, my lord?
That does not apply, lordship has kindly see, my lord. Today is 55 days, my lord. How can, my lord, this 90 days period will come, my lord?
Without any allegation, my lord, without any sufficient allegation, my
And
lord.
when this, my lord,
How can they
rejection order
detain
was passed, my lord, that was on 3/3/2025, my lord.
6/2/2025.
6/2, my lord. Then, my lord.
FIR was logged on 23.
Reject it, 3/3.
Reject order,
3/3 order, my lord, they have said, my lord, But, my lord, there is no extension of time, my lord. Why, my lord? When 90 days will be over, then only my lord extension of time question of
That is,
that.
my lord, that is not my submission. That is their submission, my lord.
That may be
Extension
some-
period is not required, my lord. It is their submission. Specifically submitted, para number 5, that the prayed for extension, IO has not prayed for extension of the period of investigation, but she objected to the bail petition, only objection. Because that detention period was not very less there, that's why the IO has objected, my lord. But 54
No, see,
days, my lord.
question of extension of time will definitely will not arise at this stage also, or at that stage also, because after 90 days or in between 90 days, there may be a prayer for extension of the period of investigation because there is a procedure. So, but at the juncture of 30 days, 50 days, there may not be any prayer. Otherwise, I have to paste the case diary and will pass the order.
My
Now,
lord,
as per your submission from the prosecution, there are sufficient materials, 164 are there. No, you are the person through whom the new recruitment were there in the as a alpha cadre. So that is there. That is the submission of the person. So I have to go through the case diary.
my lord,
Yes,
so
I
far as my
understand.
knowledge is concerned, my lord, from the concerned learned council from the Dibrugarh, the 164 statement is not there, my lord. If it was there, no, that reflect করছে কিন্তু একটু নহয়, একটু নহয় বলে 164 statement. There is no any 164 statement.
As per you, dear 164 was not recorded.
Yes, madam.
But 161 is available.
161 is available.
164 statement is available so far as my knowledge is concerned. My learned friend has told me.
Those two victims were already
164
recovered.
statement, one joint of Borua.
Where the victims were recovered already? Is there any instructions from your side? Because they were missing.
Victim, I do not know, my lord. That is
As
after
per
the
the
part of the
allegation,
investigation.
you have submitted that 2 youths were missing.
Yes, as per the
So,
FIR, by.
whether they have already recovered or
Rakesh Gogoi and Vicky Gogoi, my lord.
If it's the part of the investigation, that is, I have no knowledge regarding that, my lord. A FIR was lodged on 2023. He was arrested on 6/2/2025 after the gap of 2 years. 19/6/2023 FIR was lodged. 18/6, sorry, madam. 18/6/2023 FIR was lodged.
18/6/2023.
Huang Police Station. And after the gap of more than 1.5 years, my lord, he was arrested in connection with this case. All the accused person had granted bail, my lord. I may report against me, there is no any single allegation, my lord. My lord, considering my detention period, my lord, as well as my health condition, my lord, lordship may granted me bail, my lord.
We failed to case diary. I'll pass the order, page the case diary. 39. Yes.
POCSO, my lord, so notices were to be sent, my lord. We took steps, my lord.
So this is already written, Borga, or
Office note says, my lord, it is pending, no? It is awaited, my lord.
service is still awaited.
The
Do
only
you
thing
have
is-
any instructions in that?
That part I.
Only thing, my lord, here, my lord, on the grounds of arrest, my lord.
Search is submitted in this case, ma'am.
She has already submitted.
Search is submitted.
No, no, grounds of arrest, my lord, that part, my lord, from page 23, my lord, 24 and 25, my lord.
20.
23, my lord. That is the arrest memo, my lord. And
So
24.
do you have, you have not annexed any certificate copy? Do you have certificate copies?
These are the photocopies of the, my lord. These are authentic, my lord.
Huh?
Authentic, my lord.
Because my lord,
No, nowadays everything is happening.
no, my lord, it
Okay.
can possibly, my lord. Because we have signed also, my lord, to be the true copy, my lord, signatures of our colleague are also there, my lord, certifying it to be the true copy, my lord.
Oh, this arrest come instruction memo is a certificate copy, undoubtedly.
Yes.
But 24, what about 24?
24, my lord,
Who issued this one?
24 possibly given to the accused person, my lord, but there is a seal in the top of it, my lord.
If it is originally given to it, then why it is written as the certificate to be true?
Because
By
we
whom?
have to, my lord, because the.
It is by
filing-
you only.
Yes, for filing this.
Filing section.
Yes, filing section, it is required, my lord.
This is the
47.
notice received by you.
Yes.
I mean the accused.
Accused. 47 that, and then now 25 is that 48, my lord. Information to the family members, my lord. And that grounds also we have taken, my lord.
Now see, Borwa, there are things that the office note says that service is awaited. Obviously, it may be under section 6 of the POCSO, I think.
4, my lord.
4 POCSO. Then what to do? But there are, what I'm saying that the service is awaited for POCSO.
My lord.
It's explicit that the respondent should be heard.
Oh, my lord.
But they are coming with a ground of this arrest only. That is the issue.
47, my lord, sir. Our hands are tied, my lord. We cannot submit anything.
And what to do?
Also,
We are not on that merits. Merits may be there now. As per merit,
Merit
may,
definitely, my lord,
maybe,
because it is
maybe.
charged, my lord. So there has to be, my lord, merit, my lord. Otherwise, charges would have not filed, my lord.
Revan's case was that para 21 conclusion, my lord. That filing of charges also already seen that, my lord. In Purkaster's case also para
So
21.
even, my lord, after filing of charges also, my lord, as far, my lord, this, my lord, Gyan Kumar case, my lord.
It will be
It will be considered during trial also, my lord.
Yes.
And my lord, few days ago, my lord, I found a decision, my lord, one person is acquitted, my lord, only because of non-participating of 47 notice, my lord. Supreme Court, my lord.
Acquitted.
Acquitted, my lord. He was convicted, my lord, but he was acquitted, my lord. Because 47, the only ground was taken by the, my lord. Appellant was that, my lord, 47 notice not served, my lord. Pursuant to Gyan Kumar and Praveen Purkaster.
Now it has been clarified also that all particulars need to be given. Again, my lord, recently.
Actually, section was from the earlier
Yes,
itself,
yes,
section
ma'am.
was there. And
Yes,
the first
yes.
section, the particulars of the
Yes.
the grounds of arrest and the particulars, every
Yes.
particulars is to be
Yes.
intimated to the accused, but that was going
In
on.
1976
And-
itself, my lordship has seen that.
Yes,
Yes,
that is also there. But the question is that
In between
it
it-
was running in that
Actually,
manner.
my lord, that is the procedure followed, my lord, and nobody is challenged, my lord. Now, the after coming of Gyan Kumar case, my lord, everybody has started challenging that ground, my lord. That is why, my lord, pursuant to these two orders, my lord.
On that
Yes,
count,
yes,
that
yes,
Bansal's
granted.
case first, my lord. Pankaj Bansal's case, my lord.
Pankaj Bansal's
They are
case.
of probably Purkaster and now we are. Vihan has made it clear that even there is statutory restrictions, my lord.
That part is
Yes.
cleared, and even after the filing of the charge sheet
Yes.
also, that part is also clear.
Yes.
Even
Now, as per Bihan. That is issue.
So once we can show that it has been violated, my lord, possibly that right, absolute right accrues, my lord.
Okay, I'll pass your order.
Much obliged.
Can you tell us the CS number just?
Yes, my lord. My CS number 07/2025.
Yes.
Dated 28/2/2025.
Much obliged. Lordship has further similar that not necessary, my lord. One order.
Pardon?
By your lordships, my lord, that should I place it?
No, it's
Not
it's
necessary.
okay.
Obliged.
40.
My pleasure, lordships. I'm already on bail.
Interim.
Interim. FIR lordships annexer 1 phase 10. English
Page?
phase 10.
Page 10. Yes.
With due respect, I humbly submit that at around 6 a.m., the accused person listed below legally entered the land owned by the complainant's husband, cut down the trees, vegetations, forcibly started construction a house. When the complainant, along with her son and husband, tried to stop them, the accused persons assaulted them with matches, roach, and other weapons with the intent to kill. They severely beat the complainant and her husband, causing grievous hurts to various parts of the bodies. Later, the complainant called 108, arranged for an ambulance to admit himself and her husband to Dhuburi Medical College, where they will receive treatment. Since her husband's condition was critical, the doctor referred him to Guwahati Medical College. His condition remains critically at present. But here in this case, the petitioner's name is initially. Actually, the petitioner is not stated with the accused petitioners, which is name accused, my lord. I also, my name is also shown in the FIR, but I was not I am not staying with these people, my lord. He's stay away from other side, my lord, because accused, huh? Initially. Initially, serial 2. What happened, my lord? The incident took place, my lord. Dhuburi PS, my lord, it is incident took place, my lord. Bor the petitioner is stated, my lord, he is staying at, my lord, to Kashua Kash part 2. An incident took place, my lord. What is this also? What incident took place, my lord? It is line number. Is it Dhuburi? Yes. No, okay, that under heading place to go to see it.
Now, are you cooperating with the investigation?
Yes, yes, my lord. He has already made statement, my lord. Why no?
Is there any
Actually,
jury
incident
report
took
was
place
also
in different place, my lord, and I'm staying in different.
The person died later on.
Oh,
later on
he
died.
subsequently died.
Due to brain injury.
And at the time of incident, my lord, he was not available because he was far away from the place where the occurrence took place, my lord.
Otherwise, he is a FIM accused and his name is reflected as accused number 2.
Here if you look into the SMS lordship, SMS lordship, his name is Inis. Inis.
Yes.
But here it is Eunice.
Eunice.
But I also want to clear here that lordship. His statement is recorded. His statement is there. He also stated that he went to the place, but he was not just to look what is there, lordship. But once 83 statement is there, lordship, where Eunice name is there, Inis, the FIR name, INNUS, lordship. And it is role is also there. He hit him on the back side, lordship. It is there, 183 statement, lordship. So the thing is that if you look into this piece of evidence, lordship, the material is there. And his presence is also, he is not denied. He may be at different place, but
Yes, at that when the actually occurrence took place in the early in the morning, 6 p.m. and he incident took place Borabhila, first part, PS district Dhuburi. But he was staying, my lord, he is staying 7 kilometers away, Kashua Khas. He at that time he was in his own home when he informed because others are brother of this petitioner, then he came to the place and he took the person who is injured to the hospital, my lord. He was there, but he did not see the incident, my lord. Later on he came. That is why I got bail, my lord. Incident took place Boravilla part first part PS. I have annexed the person who is annexed is, my lord, Aadhaar card, my lord, that is page 16A. Translated 16 page annexed 3.
This is the statement of the 15 lots, one of the 15. He also stated that he was there at the time of the incident, but he does not know, he just want to observe there.
Because he was not staying there.
Moreover, Lordship,
That is why.
189 P is there. It is unlawful assembly, joining unlawful assembly, Lordship. This is statement of few pages before, Lordship.
He came later on. When the incident took place, he was not there. He came later on and he was there. Because incident took place Boravilla and the accused petitioner staying at Kashwakas, which is 7 kilometers away from the incident. And at the time of incident, he was not there. Later on, he came, of course, because they are brother of the accused. Mother. As soon as he informed the incident, he came to the place, mother. That is why it is stated that he was there. And he is a master mystery, mother. He is working as a mystery. And I have annexed the.
It is true that there is some land dispute is there, Lordship.
Yes, actually what happened, my lord, in this case, my lord, land dispute was there, but not with the particular person whose name is shown in the FIR. There is another person where the land dispute, they all are neighbor, my lord. The other accused person were neighbor. They were not actually took place in the, they were not participating in the incident, my lord. They are just neighbors. And that petitioner is so far away from the person, far away from his home where the incident took place, my lord. That is my argument. An incident took place at about 6 p.m. It is inserted in the FIR also. Latipa Sotaman Bazat. At the time he was in his own house. And I have annexed Aadhaar card also showing that I am not, my house is not with them.
He was there, but whether he was also inflicted injury on others.
Yes, it is there. In his, I have given Lordship. So his role is there. His backside.
Initial.
In his says hit on the backside of the victim.
Anyway, any other submission from your side?
No. On my statement, his statement is recorded. He appeared, but material is there. I want to point out this one.
No, but he belongs to other village.
He belongs to as per statement, but he stated that he has not just want to look into he just a bystander type. He has stated like that much. He don't know about anything, Lordship. He just went there
Where is the statement of Yunus?
My lordship, I mean. Few pages back, like the back side of the circular, maybe.
Heard MSKDB, the learned counsel for the petition. And also heard Mr. K. Kidas, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. City received, whereas the same harmful site. Next paragraph. Mrs. Davy, the MS Davy, the learned counsel for the petitioner, submitted in this regard that present accused petitioner is innocent and he is no way connected in the alleged offense. He resides about 7 kilometers far from the place of incident, and neither he is the neighbor nor he is other way related in the present case. However, it is a fact that after getting the information, he went to the place of occurrence and came to know about the incident. But incident was stopped. Further, she submitted that after obtaining the order of interim pre-arrest bail, the present petitioner appeared before the IO, who cooperated in the investigation, and his statement is also recorded under section 161 CRPC. Poster. He is still ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of pre-arrest bail. Next one, Mr. Das, the learned additional PP submitted in this regard that the present accused petitioner appeared before the IO, cooperated in the investigation, and his statement is also recorded on section 161 CRPC. Stop. But Mr. Das submitted that though he denied his involvement in the alleged offense, but from the statement made by the witnesses as well as the victims, he took active part in the said offense. And further, he submitted, however, he submitted that there is
that name is different, my lord, though he submitted like that.
Submitted that there is some differences in the spelling of the name of the present petitioner, as the name which has been uttered by the witnesses is Innos Ali, INNAS Innos, whereas present petitioner's name is pronounced spelled as YUNNUS Innos. Yunus. However, he submitted that considering the materials available in the case diary and the custodial interrogation of the present accused petitioner may be required for the interest of the investigation. Next para, hearing this submission made by learned counsel for both sides, I have also perused the case diary. It reveals that the accused petitioner appeared before the IO, and his statement is also reported under section 161 CRPC. CRPC accordingly, and he also cooperated in the investigation. Further, from his statement, it is seen that the person he came to the place of occurrence where he originally original place of residence and coming to know about the incident only. He arrived at the place of occurrence and when the matter was intimated to him. But from the case diary, it is seen that because he is the resident of one Kachu
Kashwaka.
KACHU Kachar Mokas
Kashwar, Kashwar,
KACHURA Kachwar
Kashwa,
Kachwa
KACHUAAHAS Part 2.
Kachwakas Part 2 and not the resident of Borvilla where the incident had happened. Further considering the materials available in the case diary, the conduct of the accused petitioner, I find that custody interrogation may not be necessary for the interest of the investigation, and accordingly, I find it a fit case to extend the privilege of pre-arrest bail to the present accused petitioner, and accordingly, the order of interim pre-arrest bail dated
28/12/2000 with 24.
2024 is hereby made absolute with the same terms and conditions. With the above observation, people present stands disposed.
Have your blessed.
Lordship, I want to state here that it is not up to date, Lordship.
Up to date CD is called for, my lord.
But his statements I have not found, Lordship. It was updated till 12/12/2024.
You got the bail order when?
After getting the bail order, I appeared on 26/2, my lord. After that, I appeared, my lord.
Lordship, after that.
The petitioner
The
number.
pre-arrest bail you got when? Like interim order?
Interim, my lord.
Maybe on 18/2/2025.
My lord, 18/2/2025. At that time, after the.
18/2.
Yes, my lord. And he appeared on 26/27, like that, my lord.
So it needs
So
to be
after that
up to
CD
date.
is.
It's a updated till?
Updated till 12/12/2024.
That apart, my lord, only one person got interim protections, other two not, my lord. So they are also inclined to appear, my lord. If your lordship, please, my lord, they also granted interim protection so that they can be appeared, my lord. Actually, my lord, what happened, my lord, the petitioner number one is the owner of the vehicle and other to hire his vehicle to bring some buffalo from Dhamazi. And I have annexed the receipt of the buffaloes, my lord. So if lordship please to grant them interim protection, then they will also appear, my lord, because.
Since there may be some reasons after hearing you, the a coordinate bench of this court had rejected the prayer of other two and allowed this at one. So I do not think it will be very proper to pass any order on that.
When the petition number was granted interim protection, I only prayed for interim of petition number one only, my lord, because he is the owner. And on that day, my lord, the CDS also called for, my lord. CD was not come for only for the first time that was happened, my lord. Thereafter, my lord, up to that CD was called for, my lord, on last date, and also not.
And your petition number one is Shukud Ali.
Yes, my lord. And other two are the farmer, my lord. And prior to the alleged incident, it is correct they went to Dhamazi, my lord, to purchase some buffalo. And they purchased some buffalo and took two buffaloes in the vehicle of the petitioner number one.
But this petitioner number one, he is the owner of the vehicle.
Vehicle, my lord.
So that is the reason I think let us say that.
Please, my lord, you granted, my lord, interim protection. The other petitioner also will appear and cooperate with the investigation, my lord.
Okay, I don't think it is proper. Heard Mr. M.A.I. Hussain, the learned counsel for the petitioner, and also heard Mr. K.K. Das, the learned additional briefly appearing on behalf of state respondent. Post-op, next para CD received, but it is submitted by Mr. Das that CD is updated only 12/12/2024, and the order of interim was granted to the petitioner number one on 18/2/2025. Mr. Hussain further submitted that after obtaining the interim pre-arrest bail, the petitioner number 1 already appeared before the investigating authority on 27/2/2025, and his statement is also recorded. In view of this, later updated case diary be called for, and the IOE is hereby directed to send the, and I will also hereby directed to furnish the statement of the accused petitioner if already recorded in connection with this case. It is also said that only accused petitioner number 1 was an interim bail, and the other 2 accused petitioners are interim prayer was not considered on 18/2/2025. List when it can be listed?
21st April.
21st April.
Or-
Basis, I think.
It's from now was a Lakhimpur, my lord. 24.
24?
The other are not in interim manner, so that may be given, my
No,
lord.
prior view, we don't have any date.
And date, no.
24.
After vacation, my lord.
24. 24 for. 24 for an interim for the response petition number 1 shall be extended till next date of listing. Okay.
42.
My lord, 482 application, anticipatory bail, my lord. On the last occasion, my lord, interim was granted and.
Interim was granted?
Yes, my lord.
Update CD is not available.
Yes.
It is not up to date.
It's not up to date.
Not up to date.
Your interim was granted on 10/2.
Yes, my lord.
I think so. And,
10/2.
and your updated is, case is updated till?
It is up to lordship. Twenty-one one.
21/1.
20.
AK order ho 21/1 only updated as and interim was granted on 10/2, same order. And the updated case diary be called for interim be extended till next date of listing. Till when it can be listed?
CD need to be returned then.
CD be returned for
On,
this way.
2nd of May, lord.
2nd of, till 2nd of May, your interim.
I'm deeply impressed.
43.
CD is available here?
No.
Are you on interim?
No.
No, not on interim. CD not received, issue reminder. Yes, he is not on interim, so let it be on 21, 22, 23, wherever, but after view only.
After view. 22.
22. You're listing it on 22? Hope we will be able to. 23. She's suggesting that it should be 23, 22, lots many pages.
Lordship. Then
23, 4.
23.
3, 4.
Oblige.
44.
My pleasure, lordship.
Yes. Here we have received the case diary.
Here in this case, I am appearing for the informal method.
He received that.
Before my learned friend starts, may I submit one thing? Here in this case, he have taken a plea that another case which was pending between the parties is the reason for filing this case. So that in that case, lordship, one anticipated bail application is filed. That is AB number 533 of 2025. Can it be taken up together?
AB
533 of 2025. Can it be taken up together, lordship? Because
They are also the informant file the anticipatory.
not informant is relative, lordship.
Okay.
তোমাৰ যি তুমি মহিলাৰ যিটো কথাটো কৈছা সেইটো বেল এপ্লিকেশ্যন পেণ্ডিং আছে।
That's this case are separate, your lordship. That's filed by us, your lordships. On
separate, but you people lordship see their petition, they have
20th April, your lordship, 2024, your lordship. That's not connected to us. It's separate, your lordship.
No, that is may not be connected, but the question he he raised the issue that as per your submission,
Yes, it is at
that-
page 24 of their petition, they have enclosed the document also, and the FIR also. That,
FIR.
Yes, page 22, your lordship will find. Page 22.
It's a
This-
close case, we
in-
file
in
it.
that case, lordship anticipated bail is pending, therefore I am praying, this is not a lordship subsequent documents or something. They have included that document in their petition itself. Therefore, I was praying.
It's a, our case, we file against the informant's husband, your lordship.
no, that is there. So your
Mhm.
plea is that you have already filed one FIR against the husband of the informant
Lordship.
on that grudge or as a counter.
And they
This
lodged the
basis,
subpoena.
that's what he is submitting.
And on that FIR, your lordship, on our close case, your lordship, the informant husband appeared earlier 2 times, your lordship. On first time, this honorable court rejected the bail prayer of the informant husband on 5th June 2024. Second time, your lordship, rejected second bail prayer, your lordship, on 2nd August of 2024. Wherein this honorable court directed the informant husband to surrender, your lordship, and close the FIR. Bail application.
No, but Mr. Ahmed, whether the AB is still pending.
Pending, subsequent bail application is fine.
That is,
AB number 533 of 2025.
but
I am
in page
appealing
number
that.
29, your lordship, page number 29, that close case, lordship, informant husband, the petitioner is liberty to approach the before the learned disposition of POCSO. Then of filing a bail application, the same will be considered and is directed to surrender, your lordship.
Most probably, instead of surrendering, he may have approached with another petition that I don't know.
Some other grounds are there, and I am not disclosing those at this stage. The lordship may tag it together, I will submit on that.
May kindly be taken, your lordship.
Yes, otherwise we have received. Updated one is there. Can you tell us, Mr. Ahmed, when the AB is
That
fixed?
date is not fixed. In that case, date is not fixed.
It is after 2 weeks. It is after 2 weeks only.
We need to send back that to the lordship. Lordship may fix any date next week.
Next week we don't have. That is the issue. We have the problem. Otherwise, we have.
In our case, your lordship, already service complete and CD is available, your lordship.
The service is complete. That is why Mr. Ahmed is appearing also.
And CD also available, your lordship. Here the petitioner, both the petitioner are husband and wife. I pray to heard this matter, your lordship.
Yes, what is the submission? Otherwise, we may hear it. I don't know.
Lordship may take you out tomorrow or day after tomorrow, any date. Lordship.
No, we
Because
don't
otherwise,
have. We don't have.
Here, lordship, the cross case is there, lordship, because they are saying cross case, and in my case also that they have with malafide intention have lost the case. If your lordship takes up both the case, from both the cases, it will be clear who is correct, who is wrong, lordship. That
Then
part,
if it that be the position, then definitely we case it, take it after the vacation only, not
that will
prior.
be your lordship, but
There's
I'm
no
only
implement.
praying that both the matter will be taken up. Because there it
Yes,
is there in the.
Both the matter, lordship, for hearings simultaneously, but not necessary, your lordship. There are no interim, your lordship, both
No,
are.
there is a principle, in fact, when there is a cross case.
Cross
Or it
case,
is,
that's another
it
issue,
seems
your
to be
lordship.
cross case.
And
Then
loss
matter
is
has to be
earlier.
heard by one in the same court or on the same hearing. That is the
Cross
principle.
case not
otherwise.
necessary, your lordship.
Huh?
Cross case is not necessary, your lordship.
It's
To
not
heard together,
necessary.
your lordship.
No,
But
that is
if
the
in a-
principle. That's what I'm saying.
Lordship.
As a principle, actually court case is there. Who is the aggressor? Who is these things are there. So even in trial cases also, 2 cases should be heard or should be tried together. So if it had been that principle, then these 2 matters, they're submitting Mr. Ahmed that it has to be picked up. In that case, we are fixing it after Bihu only, not prior.
Before Bihu, lordship.
We don't have any. We both don't have any dates.
There is long dates. Long.
What to do? We don't have.
They
any
can be
time.
10 or 11, your lordship.
We don't have any dates. We cannot.
Today is fast, your lordship. 10 or 11, your lordship, before.
We cannot take.
If
We
that-
don't have dates. Because these 2 days, lost every motion matters will be there and we lots of fixed matters are already 10 and 10, 9, 10, 8, 9, flourishing with the dates. And 11, we are listing less numbers of matters with intention, I may be in leave. I don't know what will happen because I'm going in the morning at Hyderabad only. That's why. If I am in leave, then entire matter will be tested. That's why I'm listing less numbers of matters in 11. 10, up to 10 is flourishing. We cannot. Some of the important things are there where we are posting it if necessary. Otherwise, all are after view.
Can it be on 21st April, on a fixed date?
21st, I don't know. 21st, can it be? Okay, we'll try on 21st. After all, it is a AB matter, isn't it? You are not, your petitioner is not on behind the jail. Then it's okay. It can be. Somehow you manage. Better to return, I think, or 21st, up to 21st, can it be kept or what?
They can use supplementary case diary also if you require.
Let it be retained. Otherwise, otherwise it may not reach also. The order kori hearing the submission made by learned. Heard Mr. A.A.R. Karim, the learned counsel for the petitioner, and also heard Mr. K.K. Das, the learned additional PP for the state respondent number 1, and Mr. A. Ahmed, the learned advocate appearing on behalf of the informant. Next, considering the submission made by Mr. Ahmed, that the matter be listed along with AB number 533/2025. 25 post CD agote receive korali DD kora and list accordingly on 21st, no? 21/4/2025. Both the matters of what CD be retained till next date of listing. So we are retaining the case.
Oblige.
For order Sergeant 47. Non-APS last date to 90. Ever 9. Non-APS on call for the petitioner. List accordingly after 2 weeks. 48.
May I please, Your Lordship?
Yes, one I is there, na?
Lordship, this one IA. This application is filed for relaxation of a bail order, Your Lordship. The petitioner was granted bail on 8/10/2018, Your Lordship. This was a case here, if Lordship remembers, lots number of APSC candidates were arrested, Your Lordship. In connection with the APSC scam relating to the Rakesh Pal, Your Lordship. That was the case, Your Lordship. Almost there were 74 number of accused in this case, Your Lordship. And subsequently in this case, charges were framed, Your Lordship. Thereafter, almost 16 number of witnesses were examined, Your Lordship. Thereafter, there are some few more arrests, Your Lordship. And the stage of the case is at copy, Your Lordship, for the other accused, Your Lordship. Time before, Your Lordship, for relaxation of a condition of the bail order, Your Lordship. And this honorable court and the lower court as well has also relaxed this condition for this previously arrested accused, Your Lordship. I'll take Your Lordship to the bail order, which is at page number 12, Your Lordship. This was a common order passed, Your Lordship, and I have filed this petition for Himanshu Chaudhary, which was the number 1, Your Lordship. If I can take Your Lordship to the condition, this is at page number 16, Your Lordship.
Your name is
Himanshu Chaudhary, Your Lordship.
Raju Saha versus State.
First one is Himanshu Chaudhary, Your Lordship. At the top, Your Lordship.
Oh.
Your Lordship. You know, page number 12.
Yes, Himanshu.
Only for the Himanshu. This is only for Himanshu Chaudhary, Your Lordship. And the condition, Your Lordship, I am taking Your Lordship to page number 16, Your Lordship. Condition 3, Your Lordship. They would not leave the territorial limit of city of Guwahati without the written permission of the trial court and without informing the investigating agency, Your Lordship. I am paying this before this Lordship to modify this order, Your Lordship.
Bail condition number?
3, Your Lordship, at page number 16. And similarly situated co-accused in other cases also. This Honorable High Court has already relaxed this condition, Your Lordship. I will take Your Lordship to a modification order, Your Lordship. This is at page number 20, Your Lordship. This was filed by one of the co-accused, Your Lordship. In her case, Your Lordship, parents were suffering from some medical difficulties, Your Lordship. On these conditions, her conditions were relaxed, Your Lordship. And similarly, Your Lordship, if I take Your Lordship to page number 25, 23 as well, Your Lordship. This was also the modification done by the learned trial court, because few bail were granted by the Honorable High Court. Thereafter, basing on the same, few bail orders were granted by lower court as well, Your Lordship. So for those whose bail order were granted, the conditions were same, Your Lordship, for all the accused. For lower court as well.
No, but why you need? What is the reason?
Lordship, in my case, Your Lordship, I am married to one Pallavi Chaudhary, and she's a resident of Guwahati, Your Lordship. And I am blessed with a baby boy, Your Lordship, also. From the date of this bail order, Your Lordship, I am residing at Guwahati, Your Lordship. Because of the condition of the bail order at my wife's residence, Your Lordship. I do not have a permanent residence of my own, Your Lordship. My parents are staying at Gwalpara, Your Lordship. In every occasion, I have to take permission from this Honorable Court, and Honorable Court grants permission as well, Your Lordship. Whenever I apply, I get the permission as well, Your Lordship. But my parents have gone old now, Your Lordship. There are some medical emergencies. On some days, Your Lordship, I have to run urgently to the Gwalpara also, Your Lordship. So on that ground, Your Lordship, because there are some medical emergencies, someday court remains closed, Your Lordship. That is the ground I am before Your Lordship, Your Lordship. And
but otherwise, you are staying in Guwahati only.
I am staying at Guwahati, Your Lordship. As on some occasion, I have to take permission. I stay at Gwalpara for some days. Again, I come back, Your Lordship. Your Lordship. And I do not have a independent shelter at Guwahati, Your Lordship. That is another difficulty on my part, Your Lordship.
That is your adjustment.
Lordship,
Not looking at it.
And similarly, situated co-accused has already been granted by Your Lordship. Your Lord. I am also similarly situated, and the case is at the stage of copy, Your Lordship, of the evidence also. And I have complied with all the conditions of the bill. And I have been complying with the Your Lordship. I am appearing as an, and when I could not appear, I am on representation as well, Your Lordship. My submissions I have written at page number, Your Lordship, page number 6, para number 7, Your Lordship. 7 onwards, Your Lordship. 7, 8, and 9, Your Lordship.
Yes, does.
But if I look into the trial court's order, Lordship, page 26 is there. Some of the accused person, Lordship, Kamal Devnath, he has also allowed to go for Kolkata for 15 days, Lordship. But I have not seen he has applied before the trial court, Lordship.
No, Lordship, I have annexed just to show that the co-accused condition of the co-accused has already been relaxed by. I'll take Your Lordship.
This bail order was passed on when?
2018, Your Lordship. This was passed on 8/10/2018, Your Lordship.
8/10/2018.
Lordship. Lordship, that page number 25 I'll read out, Your Lordship. The prosecution has not filed any written objection against the petition number Iman filed by the accused Abhishek Barbara, whereby he has prayed to modify the condition E in paragraph 9 of the bail order, dated 12/10/2018, passed by this Honorable Court in bail application number. This order was given by the learned trial court as well, Your Lordship. And this was also allowed, Your Lordship. Trial court have also allowed, Your Lordship, and High Court have also allowed, Your Lordship. I have few other orders also.
That's okay.
Which I have not annexed, Your Lordship.
You are Mr.
S.A. Hussain, Your Lordship.
S.A. Hussain. Your name is not here.
Let's see. It is
We are on
here.
48, na?
48.
Otherwise, you have Wakalatnama. S.A. Hussain.
S.A. Hussain, Your Lordship.
I heard Mr. S.A. Hussain, the learned counsel for the petitioner, and also heard Mr. K.K. Das, the learned additional PP, appearing on behalf of state respondent. This is an application for altercation, and this interlocutory application has been filed for relaxation of the modification of bail order dated 8/10/2018, passed by this court in bail application number 2335/2018. Poster. It is submitted by Mr. Hussain that while passing the said bail order, along with the other conditions, one condition of the bail was in condition, along with the other condition, the condition number 6C was that they would not leave the territorial limits of the city of Guwahati without the written permission of the trial court and without informing the investigating agency. The said application was filed by the said bail application was filed by the present petitioner along with some others, which was accordingly allowed with some terms and conditions. Full stop. Abiding by the said terms and conditions, the present petitioner was applied for permission to leave the jurisdiction of the Guwahati, and whenever he had to go to meet his parents who were staying at Gwalpara. Presently, he is staying with her wife, with his wife in her residence, and they are also blessed with a baby boy. But presently, he is facing some problem as his parents are getting old, and due to medical urgency, he had to rush to Gwalpara, and in some occasion, he is facing some problem in taking permission from the court as well as the investigating officer. However, we are facing trial.
I'm facing trial, Your Lordship.
However, he is facing the trial and appearing before the court regularly. To fight the present petition, accordingly, it is prayed for cancellation of bail order number 6C as stated above. Next para. In this context, Mr. Das, the learned additional PP, submitted that the petitioner can take permission from the learned trial court below as well as the investigating. And now the investigating question is not there. Learned trial court below, and in every learned trial court below before leaving the Guwahati jurisdiction as complying the condition of 6C as incorporated in the bail order. Next para. Considering the submission of so and so, and especially the grounds mentioned by the learned in the petition in regards to their medical emergency of his parents, I find it justified to cancel or modified the bail order dated 8/10. Bail order 8/10/2018 passed by this court in connection with bail application number so and so. And the condition number 6C as stated above shall be considered as stand cancel. Will be is stand cancel. But our order kita dibu pare kuruke. Nidilo pathanai didibo pare. What were the bail conditions order? The bail conditions put in the order dated 8/10/2009 are as follows. Will be didibo pare. Yate ase bail condition on 8/10/2018 of page number 14. That is. Okay, your petition is done. Yes.
Regarding item number 33, madam, my lord.
33.
The matter tomorrow, my lord. Because, my lord, the one application has been disposed of by coordinate basis of the order of my lord. That's the application police, my lord.
33.
Item number 33.
Yeah, we are fixing it tomorrow.
Tomorrow, my lord. Enable me to, my lord, go to the schedule. What I found, my lord, this bench is available, my lord. And even the given matter has been listed before this bench, my lord.
But it was within the knowledge of the registry also that the court and bench will be available.
Because I thought that, my lord, this bench is not available. Now, my lord, I have fixed the matter. It is available, my lord, but today also available, my lord, and when matters, my lord, which are disposed of, what, my lord, earlier rejected, my lord.
You go through the record, let us see if it can be appropriate bench, otherwise you have to dispose of. Because subsequent notification created some. Otherwise, that was it. Obviously, there are some people facing problem also. Because if the coordinate bench is there in the outline bench, then definitely that's why 12, notice number 12 was there, in fact.
If the
It a
bench
quota
is not
level.
available, my lord, then my lord, the better way can be placed before any other bill. my lord. Taking up the-
Obviously. Let us see tomorrow it will be fixed. You, by the way, by that time you go by the record also.